Yes, Mr. Shaheen.
Yes, Your Lordship.
Sorry, can I remind Mr. Maniram? Can I remind you that you're still under oath to tell the truth? You're still to tell the truth. You're subject to your affirmation. Yeah.
Yes, Your Honor.
Thank you.
Mr. Maniram, shall we start?
Yes, sir.
Thank you. Taking you to paragraph 15 of your witness statement.
Sorry, paragraph, the second witness statement.
Mr. Maniram, second witness statement, page G274.
That's fine. Yep.
Yes.
The second sentence of paragraph 15. Therefore, the claimant's team had to renew the facility agreement, failing which such a lender might be at risk of incurring a liability in damages for breach of contract for refusing to lend. So you decided to renew the facility agreement because you were afraid that you will have the risk of incurring a liability in damages for breach of contract for refusing to lend. Is it true?
I would like to say in the way, as a banker, we have to renew. It's a review of the financials of the company. So it has reviewed the financials and to make the liability available to the customer, so in order to keep the ongoing concern.
The renewal of the facility as per your statement in paragraph 15 was to cover your own risk.
It's a risk even because at the end of the day, the bank is exposed to the liability, and the customer is not giving the documents for review purpose. So the bank in turn will take a prudent call to review and make the debt available to the customer for meeting the future requirement as well as the commitment done by the company.
So you agree with my suggestion? The renewal was to cover your own risk as per your statement under paragraph 15.
It's a risk of even the company and the bank, because bank is also exposed to the liability, which is already.
Taking you to paragraph 20. I'm surprised at the contention of D7 and that of D6 and D8. They should read the facility agreement and guarantee documents. It applies to all guarantors, right? You
Yes,
mean
it
to
is.
say that all guarantors should read the facility agreement and the guarantee documents?
All the guarantors.
Why should they read the facility agreement?
In order to understand what kind of the commitment they have given to the bank and what are the ways they have to submit the documents, what are their liabilities towards the bank. So they have to know what is the contents of the facility and the guarantee document.
So the terms of the facility agreement will confer upon the guarantors also certain obligations as well as rights.
On the guarantee.
Yes. Now, come back to paragraph 16. You are stating here, the second sentence, I submit that the conditions precedent is intended to be for the benefit of the lender, the claimant, and it is always free to waive any one or more of those conditions. Right? You have stated that.
Condition precedent is given before lending. It is in order to make sure that all the borrower as well as the guarantor comply with that.
Yeah. So it's incorrect to say that it is intended to be for the benefit of the claimant alone. I suggest it is intended for the benefit of everybody who is party to the transaction, including the borrowers and the guarantors.
The condition precedent is applicable to the borrower as well as the guarantors to apply.
Okay. In paragraph 18, third line, first two words, you are referring to digital signature. During the cross-examination, one of your colleagues, Mr. Cherian, stated that digital signature is only available for government officials and very few blue chip companies who are permitted to do that by the government of India.
You are talking on the witness statement to 15 point.
Witness statement, paragraph number 18, third line, first two words you stated digital signature. Just say whether you have mentioned digital signature there or not. It is there. Okay. Now, when I was are you listening to me, Mr. Mandara?
Yes, I am just.
While I was cross-examining your colleague, Mr. Cherian, he stated that digital signature is available only for government companies or very few selected blue chip companies who are authorized to use digital signature by government of India. Is that correct?
Individuals also can apply for a digital signature.
So you say that what Mr. Cherian said is wrong?
He might have said in his pertext that the accounts pertaining to the government accounts, they have to take a digital signature. If the lending is being given to the individuals, individuals can also go for a digital signature. In turn, whenever the requirements is there, they can upload in the MCA sites or in many of the sites where the digital signatures are required.
What do you mean by digital signature?
It's an individual who will apply for from the government of authority, and it will be in a form of a digital, which is an encrypted, and it can be embossed upon any kind of a document.
Are you aware of any application being submitted by D5 to the government for being allowed to use digital signature?
So he has not brought it to the notice of the bank.
He did not bring it to the notice of the bank, and the bank did not verify it.
He did not brought to the notice of the bank that he is using a digital signature with regarding to the whenever he wanted to do any transaction.
So D5 never used any digital signature.
He has used the digital signatures for the payments, which was signatures sent by the bank, sent by the borrowing company.
On what basis? Sorry, please continue.
It was not in a form of a digital, which has been encrypted digital signature.
It was not in the proper form of a digital signature. Right?
It was not in a form of an encrypted digital signature.
Why did you allow him, or on what basis did you allow him to use digital signature?
We have not allowed any digital signature. It was the signature sent by the company on an signed van, which is taken in the form of a fax for any kind of remittance request.
No. So you have not allowed anybody to use digital signature in this transaction. What came to you was an electronically copy-pasted signature of D5.
It is the document which was the company was holding at their level. They used to send the scanned copy in a form of a fax message, where it clearly shows that original signatures are original documents are with the company, and it is as per the understanding within a bank. They sent a fax message which is clearly shows he has signed the documents originally, which is being with the company.
Most of the signatures on such scanned copies sent to you of D5 are exactly the same, identical.
It cannot be, because it has been sent by the proper user email ID of the company, and where the authorized person of the company is sending to the bank to make an authorized payment to the supplier of the goods.
Who was that authorized person sending such documents to you?
It is the CFO of the company, or the other authorized persons, or the company email ID, we can say.
Who was the CFO of the company?
CFO Akash Garg was there during that period.
Have you seen any document authorizing him to send scanned copies to the bank?
All the documents whichever he had sent, the copy was being marked to the company's email ID, which in turn was being accessible to the other partners of the company.
You didn't answer my question. I agree with your explanation, but you didn't answer my question. Have you seen any document authorizing Mr. Akash Garg to send you instructions by scanned copies?
It was then a continuous prior to my coming. The Akash was there as a CFO of the company, and it is then a mail sent by the email sent by the company's email ID, informing that Akash and one of other colleague, I'm not sure who what's the name, that the mails will be sent through these email IDs, which can be accepted for the payment.
Have you produced those emails before this honorable court?
It's a part of the trial bundle documents where many a times even the Difc has marked a copy to Akash as a part of the emails.
Now, my question is, the authorization given to Mr. Akash and the other person, have you produced that authorization before this honorable court?
I'm not sure about it because earlier, Akash was onboarded in the company prior to my taking over as the CEO of that branch. So his business, he is dealing with a bank prior to my coming.
Paragraph number 90.
Paragraph.
The
Yes.
last line. And the same were due on the repayment date, which ran until 22nd October 2022. Right?
Yeah, it is a repayment schedule of the term loan which the bank had extended, where the last repayment date was October 2022. It clearly shows that the company's plan for the repayment for the term loan was up to the 2022 October.
Have you included your claims for repayment of the term loan in this claim?
Yeah, two term loans, which is the default term loans, it is included.
What if I say the repayment date has not yet fallen due? Your claim is premature.
This repayment, which is mentioned as in October 2022, it is a part of the term loan, which is for the third. If you see the term loan 1, which is due, which is defaulted by the company, the term loan default is there and the TR defaults are there. So whichever is more than 90 days, so automatically the systems gets classified account as a non-performing. It can be either in the form of a TR facility or it can be either for the form of a term loan.
So if the repayment date is 22nd October 2022, that particular payment, if it is not effected on that days, you still have to wait for 90 more days?
No, because prior to this one, if suppose the term loan default of pertaining to the August 2018, we can take it as an example case. If the term loan pertaining to September 2018, if it is not paid, so automatically at the end of the 3 months, it will be recognized as a non-performing. This due has not even identified because it's a long tenure period.
Coming back to paragraph 20. The availability period under the facility agreement shall automatically lapse unless extended by the lender at its discretion. Correct?
Yeah, it is a part of a review. Yeah, please.
Yes. Any amounts remaining unutilized at the end of the availability period shall automatically lapse unless extended by the lender at its discretion.
This I can very well say, since the working capital limits are there, so automatically the availability period gets increased since it is an ongoing transactions available to the customer.
Are you contradicting your own witness statement?
Extended by the lender at its discretion. That means automatic, it can be further extended by the lender.
Please read the words before that extended. Shall automatically lapse unless extended by the lender.
Yeah.
So the rule is, may I complete my question? So the rule is it will automatically lapse. And the exception is to be extended by the lender. Am I right?
That's the reason we are doing a review of the account. And at the time of the review of the account is been reviewed and giving a further period of 1 year to the customer and making him available the funds.
There is nothing on record to show that the facilities granted under the 2017 facility agreement was extended.
The 2017 facility which was extended, since there is a liability was continued and there was a review done by the bank and the review sank in a form of a sanction letter submitted to the company.
The sanction letter was not signed or accepted by anybody, which we discussed yesterday.
I can put it in such a way that whenever there was an increase in the limit, we have seen that all the defendants or all the promoters, they came together to the bank for signing. Whenever there was a case where there was no enhancement and all, they are not accepted in the case of 2015, and same has happened in the case of 2019. So it gives a picture that the promoters or the borrowers, they wanted, when there is an increase in the limit, they wanted to come to the bank together and sign the documents. And when there was no enhancement, so they just kept accepted in the form of an email that shows that they have read the terms and conditions of that sanction letter.
In paragraph 20, you have stated that under the facility agreement, the amount was underutilized. Therefore, the claimant extended the availability period. This extension of the availability period was without the knowledge or consent of the guarantors.
The guarantors are in turn, they are the promoters of the company, and on a regular basis, whenever there is a request from the company, there may be some kind of a meeting happening within the company. So one of the promoters, even if one of the promoters giving in a request for the review of the account, the bank takes in a prudent way to review the account and make available the period, extended the period.
So you mean to say that it was with the knowledge and consent of the guarantors, extension of the availability?
Yeah, it is a part of all the promoters. All the promoters are in a form of guarantors, I can say. If you see, the first two shareholders of the company are indirectly, all are the guarantors. So they are the shareholders. Yeah,
sorry. See, I'm obliged to repeat my question because you're not answering my question, but going for an explanation. So was this extension of the availability period with the knowledge and consent of the guarantors is my question. Say yes or no, and then you can explain.
It should be yes.
Yes. Now, coming to paragraph 23. You said facilities are renewed and extended without the express written consent of or even notice to the guarantors. Right? Facilities are renewed and extended without the express written consent of or even notice to the guarantors. You stated yes.
I can say that the facilities was renewed and extended since there is a request from the company, and in turn the company would have informed the guarantors with regarding to the extension of this facility.
That's an assumption. You did not inform.
We have informed to the company.
You did not inform the guarantors. My question is pertaining to the guarantors.
Guarantors, I'm not sure about it because I can say with regarding to the renewal which I have done during the Jan 2019, the copy is marked to the guarantors during my period, I can say.
Under paragraph 24, you said that it is not the obligation of the claimant to seek the consent of the guarantors, but it is the obligation of the borrower. That is D1. Right? Yes or no? So, under which provision of the facility agreement or the guarantee can you tell me it is the obligation of the borrower? Under which you made a statement, it is the obligation of the borrower. I am asking you, under which provision of the facility agreement or the guarantee?
It is, I can say, the borrower, the D1, which is there, should send the renewal letters to all the guarantors informing the status of the account.
Where is it stated in the facility agreement?
I'm not sure where it is, but it is in this mentioned in the sanction letters that the copy should be shared with all the guarantors and bank and the promoters or the authorized signatories. They have to obtain the signature from the guarantor and submit to us.
Can you please show me that provision in the sanction letter?
In the sanction letter, it is clearly states that these are the following terms and the conditions. It is signed by the promoter of the company or authorized signatory of the company, and below that there is a signatories to be obtained from the guarantors. It clearly shows that the company has to take from the signatures from the guarantors.
Were such signatures obtained on the sanction letter issued on 5th January 2019?
5th January, I recorded my statement saying that whenever there was no increase in the limits, none of the guarantors as well as the borrowers, they have signed the sanction letter. So it clearly shows that even they are aware of the limits, extended limits, they have not signed it.
Suppose the borrower does not inform the guarantors. You said it is the obligation of the borrower, but suppose the borrower does not inform the guarantors. What would be the consequence?
In the January 2019 case, I believe that we have sent a copy even to the guarantors.
Quote paragraph number 25. Second line towards the end, it begins, for a renewal, if the sanction letter is signed by the promoters, that is sufficient for the purpose of renewal.
Yeah.
Right? So
yes,
for the renewal, you require the signature of the promoters on the sanction letter.
For Jan 2019's renew sanction letter, you mean?
No, first you have stated that for a renewal, if the sanction letter is signed by the promoters, the same is sufficient for the purpose of renewal. I'm telling you, going by this logic, for the purpose of renewal, the sanction letter should be signed by the promoters. Am I right or wrong?
Should be signed by the promoters?
Yes. So the January 5th, 2019 sanction letter was not signed by the promoters.
The same I have recorded earlier that January 2019, there was no increase in any kind of a limit, and hence it was not signed.
No, first, if you could answer me yes or no, I'm asking you. The January 5th, 2019 sanction letter was not signed by the promoters. Yes or no?
Yes.
It was not. Now you can explain.
The explanation, as I said in the earlier case, whenever there was increase in the limits, the promoters as well as the guarantors have signed the sanction letter, acknowledged the debt, and accepted that there is an increase in the limit. So it stands good that once they have accepted the earlier sanction letter, when there is no increase in the limits, subsequent sanction letters will follow the earlier sanction letters which are signed together.
Paragraph number 26 and 27. In 26, you say all utilization requests are available in original signed copies. 27, I submit that I have the original signed copy. Have you produced any of those originals before this honorable court? Yes or no, and then you can explain.
I'm not sure about whether it is produced before the honorable court because I am a witness to the statement. It might have been submitted by my counsel and it is available even in the bank and it is the counsel for verification of any of the whosoever is required to see that original documents.
Paragraph 28. The digital signature issue was around the period when a dispute arose between D4 and D5. So until then, were you using the digital signatures of D5?
It was not a digital signature. The transaction request came in a form of a digital payment. It is signed by in a form of a fax digital signature. No digital signature used.
So here by digital signature, you mean a scanned copy.
Scanned copy sent in a form of a fax. The original will be available with the company.
Statement paragraph number 23. You're saying that I confirm that the claimant renewed the facility agreement of 2018-2019 because the first defendant provided the essential review documents and the facility was not fully utilized. Right?
What paragraph are you on?
I could not get which is a page, sir.
Page G238.
238 statement 1. Witness statement 1.
Paragraph number 22.
Or statement 1?
Yes, Your Honor. Witness statement 1.
Yeah, and page G238.
You're saying that the claimant renewed the facility agreement of 2018-19. Was there a facility agreement for 2018-19?
The first defendant has provided the review documents, hence the limits was reviewed.
May I request you? I asked you, was there a facility agreement for 2018-19? Yes or no? Then you explain.
No. 2018-19, there was no fresh facility agreement was drawn. Since there was no increase in the limit, the previous one, which was being executed by all the borrowers as well as the guarantor, that stands good for the future review of the accounts.
So the statement, the claimant renewed the facility agreement of 2018-2019 is wrong. It's incorrect. Because there was no facility agreement of 2000.
It is about the concept of review of the accounts.
Were you doing site visits during your tenure?
This particular unit I have visited.
I didn't get you. Were you doing visits during your tenure was the question.
Yeah, I have done the site visit of this company.
who was in charge of the project? Who was explaining to you the technical aspects of the project and business prospects?
When I visited, almost all the entire team was there. Even the Vijay Kapoor was there. Ravi was there. Even Sandeep Chopra was there, and many other people were there who had shown about how the operations are there and how the stock is there and what are the future projects. So I visited twice, I can say, during my period before the account turned NP.
Is it correct if I say Mr. Ravi Kuchmanji, D5, was responsible for the technical aspects of the project?
It was nowhere mentioned that Ravi Kunchmanchi. It might be, but during my period when I went, I think he was not well during that period. So other person, Mr. Sandeep Chopra, has made me to visit the entire factory. But even Ravi Kunchmanchi also is a technical person in that company.
Thank you. And even during the due diligence done prior to granting facilities, you did the due diligence and it was found that Mr. Ravi Kuchimanji had more than 25 years of experience in supply chain management.
It is stated by our first witness statement given by the chairman. He was the person who was the architect in bringing main person and introducing onboarding these clients.
And he did not have, D5 did not have any financial qualifications or background.
Financial qualification, I'm not sure, because in the statement it shows, as per the original sanction, first sanction, if you take into account, that may be the case. But over a period, if you see, from 2014 to 2020, he might be well aware of the financial operations of that company to keep the company ongoing way.
I say it was D4, Mr. Vijay Kapoor, who was completely in charge of the financial management of the company.
It may be as per the records of the company, even as per the bank knowledge also, that Mr. Vijay D4, since he is an ex-banker, he is involved in the financial aspect. But I believe that overall, all the promoters as well as the guarantors are well aware of the operations of the company. And during the period from 14, 15, 16, whenever there was a profit in the company, the same profits was being shared by all the shareholders. So everyone aware what's the financial status of the company.
I have two suggestions. My first suggestion is that the bank was negligent and went to the extent of colluding with D4 and facilitated diversion of funds from D1. Is it correct?
If you see the bank which is operating in the center like a DIFC regulated by DFSA, there is no such kind of options available. Options are there for the bank to indulge with any of the borrower and divert the funds, because we are operating as in the regulated systems as per the DIFC law and DFSA.
My second suggestion, you knew fully well that Kochar and company had acted for the defendants in this case and had confidential information. And to take advantage of such confidential information, you hired the services of Kochar and company to represent you in this case. Am I right?
No, I can believe. I already stated yesterday, we have taken the quotations and that too in the month of 2020. So the Kochar services might have been taken in the year 2017. So over a period of 2 years, there was no contact with that legal firm.
Apart from the digital signature, just one last question, Your Lordship. Apart from digital signature, is there any specific definition for electronic signature in your internal policies?
Yeah, electronic signature can be accepted in a form of, it is coming in a form of a signed document sent through fax.
Okay.
That's all, Your Lordship. I'm concluding.
Do you mean a signed document which is scanned and then faxed across?
Yeah, that can be treated as an electronic mode of communication.
I see. Yes. Mr. Kapoor.
Yes, Your Honor.
Your opportunity to cross-examine if you want to. Do you want to break first, or are you happy to go straight on?
No, we can go straight on, sir.
Yeah, may I request Lordships that
Yeah.
we can break for 5 minutes?
Yeah, Your Honor, I just wanted to have a break of 5 minutes. Here it is 2 p.m. in India. It's 2 p.m. in India.
Yeah, 5 minutes then.
Yeah, sure.
We'll resume at just before 1:45. Okay.
Yes.
Thank you.
5 minutes. Thank you, Your Honor.
Mr. Shahil, Mr. Maniram, Mr. Kapoor. That seems to be everyone. Yes, Mr. Kapoor. Are you ready, Mr. Maniram, to resume?
Yes, Your Honor.
Mr. Kapoor, it's your turn.
Thank you, Your Honor. Good afternoon, Mr. Maniram.
Yeah, good afternoon.
And are you able to hear me well?
Yeah, absolutely.
Thank you. Mr. Maniram, your tenure in the bank was from March 2018 to April 2021. Is that correct?
Yes.
And would you agree that this was the most critical time for D1 as the events unfolded?
During this period, I can say up to December, after post-December, it might have been. Earlier, if you analyze the financial statements of all the company D1, it was always a profit-earning entity where all the promoters were enjoying the benefits out of it. So it is a post-2000, December 2018, I can say, not during my full period.
Right. You mentioned yesterday that you appointed KCI through an L1 process, right? Which would have been around February of 2020 before this claim. Is that correct?
Prior to that, because it may be in the month of December, I think so. Because the mail might have been in the month of December or January 2020.
Okay, that's fine. And I just want to again reconfirm, as you already clarified yesterday, that at that point of time, you were not aware that KCI had represented D1, D2, or D4. Is that correct?
Represent D1, D2 during what, for what purpose?
Prior to this appointment, that there was any engagement which KCI had with myself, which is D4, or advised D2, which is Velocity Ventures.
It was not brought to the notice of the bank.
Right. I wanted to just reconfirm that because you already stated it yesterday in your testimony. I just wanted to reconfirm that. You also mentioned that during the regular compliance checks, which were done prior to your period by your predecessors, like in 2016, 17, 18, and 2019, the shareholding of D1 had not changed. Is that correct?
So it is stated even by my fitness 1 and 2 also. The same is with me.
Right. I would like to draw your attention to point number 35 in your first witness statement.
Yeah.
Where you have mentioned that if there was an amended MOA, it is not binding in the absence of a formal trade license issued by the Dubai Economic Department. Is that correct?
I have to just understand what it means. What you want from me?
No, I'm saying that I have read your witness statement. At point number 35, you have gone and given a clarification that in the event of a conflict between an amended memorandum of association and a trade license, that the AMOA will only be recognized if it is being submitted to the DED and a fresh trade license has been issued. Is that correct?
Yes, since there is an amendment to the MOU.
Right. So, is it correct that you were in fact aware that there was an amended memorandum of association in place around the end of 2018?
Yes, since during that period only there may be changes what the company wanted to some kind of an amendments in the MOU. I believe during that period it was there.
Okay. Is it correct that in December 2018, I met you and I informed you about substantial business opportunities being available to D1 from a multinational company?
Unless it is brought into the notice of the bank in terms of a proper communication, there may be only an orally matter informed.
No.
So it cannot be accepted in terms.
No, Mr. Maniram, I beg to differ. I just wanted to confirm that you remember that in December 2018, I actually came to the branch and submitted a copy of the agreement which we had signed with the multinational company. There was, of course, no formal covering letter, but it was we sat across the table and I informed you about it.
If the copy, if it is available in the trial bundle, I can go through and then I can give my comments, please.
No, this was just to check your understanding that when we met, I provided with you a copy of. So do you recollect that or not?
No, I'm not sure, sir, because it's almost 1.5 years since I left Dubai. 1 year, more than 1 year.
Okay. Is it correct that as a result of that discussion, I requested you to restructure or change the character of the facility without enhancing the credit limit?
No, it came as a request from the company. So accordingly, it was being processed by the bank, and the sanction letter was being served to the company, borrowing company.
The point here is that because I met you for that business opportunity, we discussed the business opportunity, and you requested that I should present the request in writing to restructure the facility without seeking an enhancement. So basically, earlier, out of the 6 million, we had 500,000 of overdraft facility, and the balance 5.95 was a LTR facility. And when I explained the business model and I gave my reasons in writing in that letter, we asked for it to be restructured into 3 million of overdraft and 3 million of LTR. That's what I'm referring to. If you like, you can refer to Exhibit I-3094.
Yes.
And I would request if you could just spend a couple of minutes just reading through the whole document, please.
3094.
3094, ending on 3095.
Yeah, the request letter based upon this only, the bank has taken a decision to review the account, and subsequently the bank has given a sanction letter in the month of Jan 2019.
Right, but does this letter anywhere use the word reduction in facilities?
Yeah, right from the beginning itself it is saying, because if you see the overdraft facility, here it is, totally it is a 6 million is the last line sentence which I can see, the proposed limit of 6 million.
And if you see the last table on the second page, it is also saying 6 million.
Let me go through this. Yes, it is there. The request is there.
Yeah, so I'm again reconfirming that the first table has a total of 6 million.
Yeah.
And the last end of the letter, the last table also adds up to 6 million.
That is a request from the company.
I understand, but it has not asked for any reduction in limits. Is that correct?
At the time of I can give an explanation. At the time of the review, the account, when in the month of the December, the request letter came from the company, where there is when we analyze the balance sheet as well as the sales process. So we, as an banker, prudent banker, taken a decision to make it restricted to total exposure of 3 million of a trade finance limit and overdraft of 50.
I think I will draw your attention to your own witness statement, where you have said that at the request of D4.
Which paragraph of which statement?
Yes, I'll just pull it out. Here on paragraph 28.
Of which statement?
First statement, Your Honor. On 10th December 2018, the fourth defendant requested the claimant on behalf of the first defendant to adjust the nature of the limit without increasing the limit. But it does not talk anywhere about reduction.
So the request is from behalf of the company is that way, but the bank, since we have taken in a review and analyzed that the total 6 million request came from the company may not be as per the projections given by the company for the future sales.
Mr. Maniram, I would request you to listen to my question. My question is, did I request for a reduction in facility?
No,
so if you can kindly answer yes or no, and then you can explain. I have no problem with that.
You are not requested. The company has not requested for the reduction. The bank, at the time of the analyzing the balance sheet of the company, future projections of the company, decided to see that the working capital TR facility, which is earlier in a form of 5.5, reduced to 3.3 million and given an overdraft facility of 500,000.
And you just mentioned in your testimony earlier, when I asked you the question that was it the most critical time for D1 during your tenure, you said that till December 2018, I don't think there was any problems. The company was doing well and it was making profits. Is that right?
Yeah, so, up to November, I can give you an explanation. Up to November, there should not have been any kind of stress or any, it may be. Because when we see the balance sheets of the June 2018, clearly shows that the company was doing well.
Right. Mr. Maniram, let's move on. I think I've asked you that question and you answered it. Is it also correct during our meeting that I also informed you that since there has been a change in the shareholding of D1, the remaining shareholders, that is D4 and D5, will continue to be involved in the shares affairs of the company? The amended memorandum of articles which you're talking about.
Yeah, unless if it is there in the trial bundle, I can go and then give the confirmed.
Okay, I think if you can refer to your own witness statement, which is first witness statement, paragraph 37.
That's what. Paragraph 35.
Yeah.
Paragraph 35.
Paragraph 27, Your Honor.
27.
Yeah. You've said here, I state that on 17th November 2018, the claimant submitted the renewal letter to its head office for its approval, and around this time, the sixth defendant had approached the claimant about its potential sale of its shares to some investor and wanted to know if the sale of shares would be absolve its liability under the guarantee. Right?
But because unless there is
you became aware of a intended sale in November, and when I met you, I handed over the amended memorandum of association showing the new shareholding.
I have to go through, just check it whether there is any kind of a change happened in the shareholding.
No, I am only asking whether you became aware of the potential shareholding change when I personally handed over a copy of the amended memorandum of association to you during the discussion we had on the new business, change of shareholding, and adjustment of limits?
No, I don't think, because whenever any kind of a change in the shareholding has to take place, the correspondent, the borrower, they have to take an approval from the bank in a form of an NOC. Subsequently, only they can do the changes in the shareholding pattern. So we have not given any kind of an NOC to the company.
That the reason I'm asking this question from you is because in your own witness statement, if you go back to section para number 35, you've gone on to clarify that you submit that in the event of a conflict between an amended memorandum of association and a trade license, if there was no change, if there was even a which was presented and it was not recorded, there was no reason to give this clarification, right?
It may be with regarding to the MOU, amended memorandum of articles, pertaining to some other aspect also. It can be, unless I can go through that MOA, I cannot comment on it.
Mr. Maniram, let me step back and go back to the question. You referred in your own witness statement that there was a potential sale of shares advised to you by defendant number 7, right? Supra Gupta.
6.
Yeah, 6th defendant, sorry. And when I met you, I handed over a signed memorandum of association, which you don't recollect. But in your own witness statement, there was no change of shareholding, there was no approval sought. You have gone and given at para 35 a detailed explanation that in case of a conflict between an amended memorandum of association and a trade license, only the trade license would prevail.
But it nowhere mentioned with regarding to the change in the shareholding pattern in this 35 statement.
Anyway, I think I made my point that you were indeed aware that there was a potential change, and is it not because of that you continue to insist on signatures of only D4 and D5 for all affairs of the company?
So none of the time the bank has given any NOC to all the partners in the company.
I agree. I'm not saying that you gave any NOC. Mr. Maniram, my question is, because it was your assumption that there is a potential shareholding change, you insisted on only the signatures of D4 and D5 to be continued for all affairs of the company.
No, not like that. Because how we could have sent a sanction letter in the month of the Jan 2019 seeking the signatures of all the guarantors.
Right. Okay. Let's move to the next question. During this time, would it be correct to say that you were aware between the period of September to December that D5 was in India?
September, which period? 2018?
Yes, 2018. And in fact, I submit to you that there were many occasions on which you were interacting with D5 to take his consent for certain matters which were relating to the companies. We were sending documents by email, which he was signing in original and sending it back to us by courier.
It may be the part of the company which might have taken a decision. As a banker, we have received the documents where we have to process as per the bank's guidelines.
No, Mr. Maniram, my question is that you were personally in dialogue and discussion with D5 because anything which had to be done required a signature of D4 and D5. You were in dialogue with him to obtain his consent and also get the necessary paperwork in place before any transaction could be processed. That was not just for D1, but other group companies as well.
I'm not sure about other group company. Let's discuss only with Velocity Industry now.
I'm not even naming the group company. I'm talking about that he was in India and you were insisting on.
As a business entrepreneur, he might have gone to the India on a business purpose, and during that period, we could have very well spoken over phone, and the company might have sent the required document to him and got the signature and submitted to the bank for making the payment. So nowhere it is a business decision of the individual person to move out of the UAE.
No, I'm not saying why he went to India. Obviously, he can travel for his personal reasons. He can travel for business reasons. I'm only saying that there was an insistence of getting signatures only from D4 and D5, whereas if we look at your internal position, the mandate which allowed 4 of the defendants with 1 from each part to execute the documents should have been sufficient to run and operate the affairs of the company. Is that correct?
Can you repeat again, because I was just, my system was going into this one, no battery. Just give me a second.
No problem. Please take your.
Yes, please. Can you repeat, please?
Yes. So I'm saying, based on our discussion just now, my question with where you answered that trade license is important and that is the ultimate document. My next question was that we were trying to find ways and means of running and managing the company with the signatures of D4 and D5, right? And I'm saying my next question that if the trade license was still valid with the same shareholders, then the old mandate of 4 signatories would have sufficed to run day-to-day affairs of the company. Is that correct?
Yeah, it is as per the board resolution of the company. If there is any kind of
Mr. Marina, I'm going to kindly request you once again, please answer the question, yes or no, and then you can kindly explain. But my question is very simple. If you, according to you, the shareholding never changed, right? That means there were 4 available signatories, right? As per the original mandate. And any 2, one from part A, one from part B, could have signed the documents of the company and allowed the company to function. Is that correct?
yes, it is a decision can be taken by the company.
Right. Now, my next question is, are you aware that during May 2019 till July 2019, you don't have to refer to a document, just please listen to the question. Are you aware that between May 2019 and July 2019, ACI was defending the D4's case in Fujairah courts in a matter pertaining to a company called Velocity Ventures FZC? Yeah, where they had asserted that Velocity Ventures FZC is the holding company of D1. I'm just asking you whether you are aware.
Yeah, since I am not sure exactly, since there is no document available as of now, it may be a case because the Velocity Foods is a different account.
No, this is not Velocity Foods. I'm sorry, Mr. You've misunderstood. I'm saying that there was a company called Velocity Ventures FZC.
FZC, okay.
Okay. Where I'm asking whether you were aware. I'm just simply asking whether you were aware, yes or no, that they were defending my case in Fujairah courts again in a matter pertaining to Velocity Ventures FZC, which they clearly asserted was the holding company of Velocity Industries, which is D1.
I'm not sure, sir, because it's 2018. I cannot comment immediately on it.
So it's not 2018. It is May 2019 to July 2019.
Still,
I mean,
I'm not
say
able
yes,
to recollect.
no. Are you aware? Yes or no? That's all.
I'm not 100% can I confirm yes or no, because unless it's a matter which is pertaining to the other free zone, other account.
Okay. No, it is not another account. We're talking about D1 only.
D1 only, but it is other free zone account, so I'm not sure, sir.
Okay. Let's move on to the next question, please. I would like you to refer to Exhibit J292.
1 second. J2.
J J for Jack, 292.
J starting from 239 it has given.
Yeah, that's right.
It has given 239. Whether it's the same document 292.
It's the last page of the same document.
Yeah, I'm scrolling down here.
So I think what I have as a reference number in my pack is J292.
Yeah, I'm going
Yes.
to that one. Sir.
It is an email of 30th July.
That is right. That is correct, sir.
Yeah, I'm
It's the
going
last page of the.
If you kindly just spend 2 minutes, 3 minutes, as much as time as you like, just to quickly read through this email.
Yeah, I can just understand that if I to go, it is a time taking. Really.
Yeah, please take your time. This is important.
Yes, please.
Okay, I'll just summarize. This email is from D7 to D4, which is myself, right? And it in the para which says quote that we have recently received a facility renewal letter from UBI and realized the bank hasn't updated the new shareholding details in their records. Also, due to non-cooperation from Mr. Ravi, the new shareholding pattern could not be registered with the Dubai Economic Department. As a result, even in the DED records, Umaku and Velocity Ventures still own the D1, which is Velocity Industries LLC, right? At this stage, there is no clarity whether Ravi will agree to sign the documentation to complete the transfer process. To resolve the current deadlock, Vijay has discussed the matter with a legal firm, Kocher and Company, who have suggested the following. So there is a process which they have outlined, right? And as you can see below, at the bottom of the page, I have forwarded this email to Ms. Nikhat Khan at Kocher and Company, right? So if you see, this email is dated 30th July 2019. And obviously, this would have been put together as a summary after this matter has been discussed for at least a few days before that, right? So it was just to summarize the understanding, and which I have forwarded to Mrs. Nikhat Khan, right? So I want to ask a question. Are you aware of this email? Were you aware of such an email?
No, not aware, sir.
Okay. Do you at least understand the nature of advice which is being taken by us from KCI in this email?
So it nowhere says what's the you're going to take. It's an email sent by Parag Gupta, the D7.
No, please, Mr. Maniram, I'm not accusing you or the bank or anything. I'm just simply asking you understand what is the nature of advice being sought. That's all.
What's the you wanted from me?
No, I don't want anything. I just want to know whether you were aware of such an email or not. Did
No,
you?
the email I am not aware, sir. It was not shared with the.
That's all. I just want to know whether you are. Now, are you aware that in the pre-trial hearing, and Your Honor, I would request your attention. In the pre-trial hearing in the present matter, KCI had gone on record to say that this advice was given by KCI on behalf of the claimant. Okay, and if we need, we can refer to the pre-trial YouTube transcript, and I can point out the exact minutes of when this was recorded, because they confirmed this during the pre-trial hearing, and it was done through the counsel who was representing them. So this was a discussion, if you remember, was going on between the counsel for 6 to 8. They were seeking certain details, certain extra information, and everything else from Kocher and Company, and you had asked me whether I had any objection. So I submit that if you would like, we can probably access that transcript or that recording at this stage, so that everybody is clear.
Is that transcript in the papers in the file?
Sir, it is in the public domain. It is a pre-trial YouTube video uploaded by the registry. Because since there was no other transcript, this is a YouTube video which has been uploaded, which is a recording of the entire session of the pre-trial hearing, sir.
Oh, let's just take it in stages. You want to establish that at the pre-trial review, it was said on behalf of the of Kushar that they gave this advice on behalf of the bank. Is that right?
That's right. It's clearly there, and I can refer to the exact.
Oh, let me just check and see whether that is disputed. If it's not disputed, we needn't look at it. But if it is disputed, we better look at it. Mrs. Khan, can you say whether that was said on your behalf at the hearing? Take a minute with Mr. Vajani.
Sorry, because my mic is switched off and I cannot speak.
Right.
Sorry, number one, I did not represent the claimant during the pre-trial. It was Mr. Alex. We had engaged a counsel. He appeared, and we did not admit anything like this. We only said that we contacted D4 because the claimant had told us that you have met D4 during the closing submission. They are having partners dispute. So during this period between May to September, we have been in contact with D4, and after that, and during this period, we were not in contact with the claimant. So I did not ever admit that from May 2019 to September 2019, I was in touch with the claimant, and not even in November, not even in October.
Well, Mr. Kapoor, I'm not going to resolve this by what you both speaking to me now. You better show me the passage that you want to rely upon.
Yeah.
And then we'll take it from there.
Yeah.
I didn't appear for the pre-trial.
No, it doesn't.
I did not say you appeared. I said the counsel who appeared for the claimant consulted with you and then confirmed on record that this was indeed an advice which was given on behalf of the claimant.
No, I cannot say that he has the authority to say this. I'm the only one who knows the facts of this case.
Right. Let's pause there. Mr. Kapoor, if this is important at this stage, then you better have an opportunity of showing or listening. Let us listen to the record of what was said, and we can take it from there.
So
do you have that? Do you have that instantly? Do you need a few minutes?
I have the link, but I'm not very sure how I can play it here. On a team meeting. But I'm sure the registry with any of the officers are there. I can point out exactly the minute to which they can forward that tape, and it's a big YouTube link which they can share, and everybody can hear it.
Right. I'll tell you what. Maitha, are you there?
Yes, Dr. Here.
Is it possible for Mr. Kapoor to, if he gives you the relevant link to the YouTube passage, that you can in some way play that on the screen, or is that technologically impossible?
I'll have to double check with IT, but I don't see any issue. So if Mr. Kapoor, please can just send me the link and the exact minute, and I'll check with the IT department.
Okay, it is the YouTube recording which has been uploaded on YouTube. So it is, the heading is called the pre-trial hearing. So if you want, I can send you the link. I'm not sure how I send it the link to you.
How should he send the link, Martha? Should he?
So just few minutes. Actually, I'll need to double check with IT first to see if this is permissible or not. But it's the pre-trial review for this case, correct? I'll be able to find it on YouTube. Yes.
I can send it if there is a way I can write a conversation or a dialogue here itself.
Yes, yes. So actually, there is a chat. So if you're,
Allow me a few minutes, please.
yes.
I'll tell you what. Let us break for 5 minutes while Mr. Kapoor tries to sort this out with the IT department, and then we'll come back. Mr. Maniram, we're going to take a very short break, a few minutes, I hope, and then come back. All right?
Yes, Your Honor. Sure.
Thank you very much.
No, you can come here.
We'll come back in 5 minutes.
Yeah, this lady is here. So, all right.
कॉन्टेक्ट नहीं किया क्या पर यूट्यूब
है नहीं?
Right. Have we made any progress?
Judge, I'm waiting for my colleague Adil to now join the hearing, and he'll be able to play the recording.
Okay, thank you very much. Is he just about here? Or will it be a few
Yes,
minutes?
yes, a minute or so.
Hello, good afternoon. I'm just playing it. Is it you can see my screen?
I can see your screen. Can everyone see the screen?
Yes, we can, Your Honor.
Thank you.
We also know that the claimant's lawyers did receive this email, and Your Lordship can, Your Honour, you can see it towards the bottom of.
Yes.
We don't quite know what advice took place, but Mr. Kapoor doesn't appear to be disputing. Be signed by the shareholder / Mr. Kapoor, and based on this, UBI will allow the utilisation of existing facilities and release the personal and corporate guarantees given to them earlier, again on this assumption.
Yep.
We don't quite know what advice took place, but Mr. Kapoor doesn't appear to be disputing the contents of this email as being a correct recollection of the conversation that he had with the claimant's lawyers. We also know that the claimant's lawyers did receive this email, and Your Lordship can, Your Honour, you can see it towards the bottom of the email. This appears to have been forwarded on to Mrs. Khan at 9:31 a.m. on the 30th of July 2019.
Yeah.
Now, when the conflict of interest issue was first raised back in December 2020, this email was not in play. It wasn't provided by D4, D7 or the claimant's lawyers. Mr. Gupta has filed a witness statement setting out the reasons why this wasn't produced at the time, and if it assists, Your Honour, that can be found at pages D694 to D696 of the PTR bundle.
Yep.
And in his sixth witness statement, Mr. Gupta notes that when he had done an initial search for emails relating to this matter, this email hadn't come up. When he tried to run another search against the various search terms he had previously put in, again, this email didn't come up. And it was only when he specifically went into his sent items and looked for the email that he was able to find it. And that's the reason he hadn't referred to it before. But what he does confirm in his witness statement, specifically at paragraphs 20 onwards, which is at page D695, is that this email records his understanding and his recollection of the advice which Mr. Kapoor had received from the claimant's lawyers in 2019 about the release of the guarantee. The claimant's response to the issue of conflict, once we noted the contents of this particular email, is first that they only advised the fourth defendant about the Dubai court proceedings, and secondly, they did not act for the fourth defendant in these proceedings. Your Honour, we say the position is not as binary as stated by the claimant's lawyers. The real issue here is whether confidential information was imparted to the claimant, and if confidential information was imparted, which relates to the subject matter of these proceedings, whether that has knowingly or unknowingly been used to the advantage of the claimant in these proceedings. Because the 6th to 8th defendants were not in direct communication with the claimant's lawyers, we do not know precisely what discussions took place or what advice was provided. And to a certain extent, it's not clear to us whether and to what extent any of this impacts upon the current proceedings. It may be that they don't, or it may be that they do. But what we require and what we are requesting from, what we have requested from the claimant's lawyers is an account of the nature of the advice that was provided, copies of any advice that was provided in relation specifically to the guarantee issue. Although, as it transpires, the issues relating to the issues between the 4th and the 5th defendant, which the claimant's lawyers were advising on that was taking place in the Dubai court, have now made their way into these proceedings and are potentially material to the dispute between the parties. And also,
can you just help me?
Yes.
It's probably my fault, but I haven't lived with this case in the same way as you all have. The confidential information which may, on one view, have been communicated to the claimant's lawyers is confidential information coming from the 4th or 5th defendant, is that right?
The 4th defendant, that's correct.
4th defendant. Well, I can see that the 4th defendant might have an objection. But why does it give the 6th to 8th defendant any objection?
We understand the 4th defendant, and Mr. Kapoor perhaps can answer this, has raised this in the issue of, specifically within the issue of there being a conflict of interest. We're not sure to what extent he has any objection to this, to the direction that is being sought, and I don't know perhaps if this would be a convenient point for me to stop and let Mr. Kapoor answer.
Not quite yet, because still not. If you're making seeking an order about it, I'd have thought it would be because your confidential information has somehow crossed the line through the medium of a lawyer. But what confidential information is there of yours that we're concerned about?
In relation to us and putting to one side anything to do with the 4th and the 5th defendants, it's in relation to the release of the guarantees. Now, it was Mr. Gupta, the 7th defendant's understanding that Mr. Kapoor was liaising with the claimant's lawyers about the release of the guarantee, how to effect that, how to liaise with the bank UBI in terms of effecting this release, and that effectively Mr. Kapoor was doing this on behalf of all of the defendants. Therefore, although there was not a direct relationship, indirectly there was confidential information being passed.
Okay. Where do you set out the order that you seek?
The order is more in the form of a broad direction, a paragraph 23 of my skeleton argument, which is a direction requiring the claimant's legal representative to file a witness statement setting out the advice provided by provided to D4 concerning, I've put here his dispute with D5 as well as the release of the guarantees, and exhibiting to that statement copies of file notes, attendance notes and correspondence relating to the same. in light of your Honour's comments, I appreciate that perhaps the reference to D5 might be a step too far, but I would ask for the rest of the directions to be ordered at today's PTR.
And what about the last sentence?
That was there to protect Mr. Kapoor because I understood he was appearing as a litigant in person. I appreciate matters are rather heated between D4 and D5. And D5 does not appear to be joining in on this particular application, but it's something that D4 has effectively started, and D6 to D8 are picking up the baton and running with it. Therefore, if certain privilege walls need to be put in place, we would not object to that.
Right. Okay. Well, shall I hear Mr. Kapoor? Mr. Kapoor, you're understanding this point, presumably. What do you want to say about it?
Well, I'm not sure that I'm able to understand it in its entirety, as I'm although representing myself, but I do not enjoy legal training as my colleagues do. But I mean, I can probably just tell you the way things went, so that it's simple, without having to go around and find refuge in words. I had engaged with the claimant's lawyers much before this suit was filed by the claimant. And at that point of time, the matters which were being discussed were on a much larger scale overall, specifically with my reference to the disputes with the defendant number 5. Right? Yeah. I had provided a lot of information which was sought. And I think the case in point at that point of time was that we were in a state of flux as far as the claimant number 1, which is the company, is concerned. Sorry, claimant number 2, defendant number 2, the company is concerned, that we were not able to move forward in doing any business. We were not able to do anything as far as the company is concerned because the bank was not allowing us to operate the account because it required claimant, which is myself, 4 and 5, to be signatories to each of the transactions, right? And on the other hand, there was pressure from defendants 6 to 8 to find a way to close the transfer in full, transfer the shares, take over the reins of the company and run with it. Because we had orders from multinationals who were willing to move ahead and giving us the opportunity to run the business and hence be able to honor our liabilities. You with me so far?
Yep.
So essentially, we gave all these details to Kocher and Company. So I think the specifics which are being sought by the council for 6 to 8, the details would be with Kocher and Company, because obviously I do not have access to my old company emails and anything else at this stage. And whatever I could provide the expert was whatever information I could find, in my other emails. And as far as this issue of conflict was concerned, it was raised right at the beginning, because obviously as my lawyers, I had disclosed a whole lot of things to them in terms of, the situation of the company or my situation with the defendant number 5 or any other residual matters, including this, new businesses which we can get or get hold of, right? And as far as defendants 6 to 8 are concerned, they would probably concur that I have always tried to enable and help them in terms of closing this transaction where they sold their shares. Now, as far as the specific question on the guarantees is concerned, there was no specific discussion on release of guarantees with anyone, because the whole thing is contingent on first the transfer of the company taking place. And this was very clearly made, informed to the claimant 6 to 8 that only and only when we can have the company fully transferred, will I be able to go and approach the bank and place before them all the facts that here is the new business, here are the new shareholders, here's how we are going to run the company, and hence seek the what you call their indulgence for removal of the guarantees. And it was very explicitly explained to them, because they were seasoned bankers and businessmen, that this can be done only and only with the consent of the bank. It's not for me or anybody else to, withdraw a guarantee, because I'm neither the recipient nor the giver of that guarantee. That is the factual position, sir.
Thank you. So, do you support the direction which D628 are asking for?
Well, to be honest, there is a whole lot of information which has been shared with my lawyer earlier, right? And my whole contention has been that if all that information is being used now by the same law firm to assist the bank in their claim, that itself is a conflict of interest. But having said that, I would obviously not be like that confidential information which has been there between them as my counsel earlier and myself should be disclosed to any other party, because it's not relevant to them.
Yeah. So you would oppose an order which the D628 seek? So you would oppose this application by D628 for a witness statement setting out the advice provided to you?
See, because the advice provided to me covered a whole lot of issues. I mean, whole lot of things. Yeah. And I do not know, and I cannot trust the lawyer for the claimant to be therefore fair in whatever they disclose and they don't disclose, because the very fact that they're representing the claimant themselves is something which I have contested, and I have respectfully put forward much earlier at the time of the summary judgment being considered.
And that was never decided? Or what was
it was never decided. In fact, I was very surprised, because I thought that was the most fundamental point which should have been looked at and decided on by the Honorable Court. And in fact, frankly, it is also very surprising that it was never picked up by defendant 628 or anybody else for that matter, because maybe it was self-serving that they were not affected by it. And now that when we are talking about certain emails which the expert has picked up, it suits them to pick it up at this stage.
Yeah, but are you renewing your application about conflict of interest?
Well, I'm not sure of the procedure, Your Honor. This is my first such endeavor. So if there is opportunity, then I definitely like to, because essentially, you cannot have a situation. I mean, very little knowledge of English law. I might say just simple common sensically that if a law firm has been representing me, getting all kinds of information from me in a wide variety of matters, is thereafter, without taking no objection from me or without discussing the matter of that thing with me and specifically taking my consent, go and start representing the claimant in this case, in a case against myself.
Yes.
I mean, that's something which I have never seen in any part of the world.
We'll come back to that in a moment. But at the moment, if D628 want the claimant's lawyers to file a witness statement setting out the advice provided to you, forget about the dispute with D5, but provided to you about the guarantees, which I think is all they're really asking for. Are you content with that, or you prefer that you say that is confidential to you and shouldn't be given to D628?
No, in fact, on the contrary, if you see the way the counsel for 628 has described the annexure in the thing, and Parag Gupta, who's one of the defendants, has actually found a similar email in his own, what you call sent emails or wherever that folder it was lying. That was the only email on the subject. So frankly, if it is only specific to the transfer of the company or potentially transferring the company or that matter, that part I have no objection to. But I would not like any other document which was shared confidentially with them should be shared with either defendant 628 or, for that matter, defendant number 5. And also, I would humbly request that if the court could guide me as to how we could take up that issue of conflict of interest on a separate note.
Okay, so just to be clear, I just want to make sure I'm not misunderstanding you. Do you have paragraph 23 of D628?
Yes, let me check here. Yes, I have the paragraph in front of me.
If you read the first sentence, they seek a direction, and this is what they're asking the court to order. Order that the claimant's legal representatives file a witness statement setting out the advice provided to D4. Now leave out the words concerning his dispute with D5 as well as just provided to D4 concerning the release of the guarantees and exhibiting to that statement copies of file notes, attendance notes, and correspondence relating to the same. If it's just about the release of the guarantees, I think I understood you not to object to that. Am I right?
Yeah, in fact, I wouldn't, because whatever information I got from them, I forwarded it to Parag Gupta, and he should have it in his own email. There's nothing more than that.
Okay, so on that limited basis, you would not object to that part of the order.
Yeah, I would.
Right. And Ms. Askarian, I think you were limiting your application to that aspect, weren't you?
Correct, Your Honour.
Right. Well, I'll ask the claimant what he has to say about it. Do you object to this an order in those terms, Mr. Barrow?
Thank you. Well, a lot of it was contingent upon what D4's position was. There was going to be an objection to it on the basis that it was legal advice privilege. If D4 waives privilege in relation to that item, then that objection falls away.
Shall I move directly to 51? Or you want me to continue over there?
Mr. Kapoor, do you want to move to 50?
I think since it's a very short gap, I would request we continue. Otherwise, somebody will say that something else was said in the middle. If you could continue, please.
Fair enough.
I do have other objections though, and other points that I think I should raise, which are relevant to it. So to the extent that privilege is waived by D4 in relation to the item, then I won't raise anything further in relation to that issue. Save to clarify that indeed it would only relate to the issues to which D4 has waived privilege, namely the release of guarantees and documents related specifically to that. The other two items, or the other two procedural objections, as it were, to this is that it's a relatively serious application to produce what would have been privileged documentation in circumstances where a skeleton was filed at 5 p.m. the business day before this PTR hearing. And no formal application has been made by D6 to D8, contrary RDC 23.2. And even if a formal application was being made, this isn't as against the claimant, it's as against Koshar. And Koshar is not a party to these proceedings. And so no application has been raised specifically against Koshar to produce this documentation. So from a procedural basis, it is objected to. My understanding, however, in any event, and perhaps the short circuit to this for the benefit of everyone, and I'll just need to, I think I've got this confirmed already, but I'm just having a double check. It is our understanding, and indeed that's my understanding from what D4 stated earlier today as well, confirms this, is that there is no, or was no advice provided by the claimant's legal representative in relation to that issue of the release of guarantees. And as such, there would be no documentation or similar related to that issue. Now that's what I've been told by my instructing solicitors. And similarly, that's what D4 appears to have confirmed as well. So to the extent that that is the final answer, and I'm just waiting to hear back from my instructing solicitors doubly confirming that, that might short circuit the entire point. To the extent that that isn't the case, though, or also were related to that point. But as I understand it, and this is an issue of confidentiality, so that the alleged conflict of interest goes towards the confidential information in section 12 of the DIFC code. And in particular, it relates to not having confidential information provided by a former client as a consequence of having acted for that client. So this is section 12.13.
Of what?
Sorry, it's not in the bundle, Your Honour, because it's sort of relatively late notice that this issue arose. If you want, I can pull it up onto the, I can share my screen if that assists.
Yeah,
so it's the Code of Best Legal Professional Practice.
Yeah.
Would you like me to share my screen, Your Honour?
Yes, please.
We have that up, Your Honour. So I think this is it. Section, it says 12.13, and this is in relation to when a lawyer should just decline to represent or withdraw from proceedings, and this is the issue that it concerns, confidential information. The lawyer has acquired confidential information concerning a former client as a consequence of having acted for that client. He must not accept instructions to act against him if a reasonable and fully informed member of the public would think it's likely that such confidential information would be used. The other client has an interest adverse to the interest of the former client, and that information is material in representing the other client in that matter. Now, it's Koshar's position that it never represented, or to the extent that any confidential information was provided to Koshar in relation to the issues mentioned in this email of July 2019, Koshar were not representing D4, but rather were representing the claimant in its interests in relation to the matters discussed within that email. As such, no confidential information was acquired as a result of any engagement between D4 and the claimant. And in relation to any confidential information which was provided by D4 to the claimant as a consequence of its engagement, and I think this is slightly separate because it relates to D4's potentially renewed conflict issue, is that is not material to this case in any event, as was confirmed previously in relation to D4's application set aside when this issue first arose.
I thought this issue wasn't decided then.
No, well, it wasn't decided at that stage, no, but that was, Koshar had confirmed its position at the time in its witness statement, stating that all of the matters that it was formally instructed by D4 upon were not matters which are relevant to the issues in dispute in this case. And that was confirmed in a witness statement by Mrs. Khan.
But no decision was taken by the judge.
Not as far as I'm aware. No, Your Honour.
So you said it's been dealt with.
Sorry, I meant dealt with by Koshar and Co. in relation to their correspondence, not dealt with by the courts, Your Honour.
Okay.
Do
you? Sorry,
just in relation to that. Sorry, just in relation to that point, and on the, if we go back to the email in question.
Yeah.
So that's at G38.
Yeah.
So I think we've already had a look at this email, and the relevant part of it is about halfway down in relation to the quote section, or below the quote section, the third bullet down. it says, oh no, sorry, apologies. At the first paragraph and the 2 lines before the end, it says, to resolve the current deadlock, VJ has discussed the matter with a legal firm who have suggested the following. It's Koshard's position that this references VJ discussing it with the claimant's legal firm, Koshard and Company, that it was Koshard was acting as or on behalf of the claimant when discussing any of the matters contained within this email. And that supports the Koshard's position that it was not acting on behalf of D4 in relation to any of the issues mentioned therein, or any of the issues which relate to the release of the, or certainly in relation to the any issues related to the release of guarantees, and that no advice was provided from Koshard as an independent legal representative to or engaged by D4 in relation to these issues. So at this stage, Your Honour, the Koshard and Company do not consent to any direction as requested by D6 to D8 on those procedural grounds as previously referenced, and also on the basis that no such advice was ever given. If it is confirmed to me or later today,
that point is not a ground of objection. Simply you say none.
Well, yes, Your Honour. Okay, well, in the context of any advice, so the objection rather would be in relation to any advice which was given in relation to this issue. It was not given in circumstances where it would create any conflict of issues.
Hold on a second. Paragraph 23 is only incidental to the conflict of interest point. It's simply seeking the advice given by your lawyers, to put it briefly, your lawyers to the fourth defendant concerning the release of the guarantees. Now, if your lawyers may have given advice, but not as independent legal representatives, then it wouldn't be privileged anyway. They'd be giving it on behalf of the bank. In which case, what's the objection?
My understanding, Your Honour, is that well,
the answer would be, your answer may be the no documents, and I can understand that. And they gave no advice, I can understand that. But what's the objection to them having to say it?
One second, Your Honour. I'm just confirming with my instructing solicitors. My understanding, Your Honour, is that the documents that were already that were provided from Koshard and Co. To D4 in relation to these proceedings are already contained within Mr. Kapoor's witness statement of March 2022 and the exhibits to that. As I understand, I'm instructed that there are no further documents.
Yeah, but that may well be the case, and there may be a very short witness statement. Therefore, there's that's not an objection to the order being made, is it? And let's cut to the chase. I mean, either there's nothing to give.
Yes,
in which case,
I've just had it confirmed. My instructing solicitors are happy to provide a witness statement confirming the same.
Okay, so what I'll do, I assume no one else wants to contribute to this discussion. I should check with the second and fifth defendants. Mr. Cheyenne, is it? Not there.
Yes, Your Lordship.
Yes. Was there anything you wanted? I don't think this affects you, but was there anything you don't want to add anything?
No,
Fine.
Your
What I'll do is I'll make an order to this effect, that the if you can make a note of this.
Your Honor, if you stop it here, I have no objection, sir.
Order the claimant's legal representative to file a witness statement setting out the advice provided to D4 concerning the release of the guarantees, and exhibiting to that statement copies of any file notes, attendance notes and correspondence relating to the same. And that's all I would order on that. I think, having heard the discussion about conflict of interest, I'm not in a position to resolve that today. I think what you need to do, Mr. Kapoor, if you want to renew the application you made apparently back in 2020, was it?
Yes, please, sir.
If you want to renew that or have it decided, you must make a separate application setting out in full the grounds on which you rely. You may already have set them out, but I haven't seen them. But if they've been set out, then you can refer to previous documents or whatever you want to do. But it must be done in a way that gives the other parties an opportunity to respond to it and have a considered hearing on just on that point alone. But you may decide you don't want to do it. But if you do want to do it, that's the way to do it. And I'm sure the registry will help you with the.
So, Mr. Shikha, you have requested to stop. I did it.
Stop it here. I mean, unless anybody else wants to continue it, I mean, I think I'm fine with this.
That's fine. Let's
Stop sharing the screen.
Thank you. Right.
So, Your Honor, my point was that it was very clearly.
Wait a second. Wait a second. Mrs. Khan wants to say something. She's got to move to a different microphone.
Thank you, Your Honor, for this opportunity. I have watched the video, and perhaps D4 did not clarify one thing, that when Mr. Alex had appeared in the PTR hearing, that time a witness statement was not filed. We have filed two witness statements on this conflict of issue, and one is at G317 to G323.
Yes, and the response to that also.
Before what are you just tell me in a sentence?
Bottom line, the fact is that when we had quoted in G317 to G323, and that is around when Mr. Alex was representing the claimant, we had not. Actually, Mr. Kapoor's file was archived, and he knows very well why we archived the file and why there was no access to any document. He knows very well. I don't want to disclose this to anybody. Just let me complete. And so we didn't have the dates. So we were under the wrong impression about the dates where we were representing D4. And when we filed the second witness statement, we unarchived the files. We came to know exactly when we were representing D4, and we confirmed that from May to September, that's the period we were engaged by D4. We were not engaged by the claimant, and we clarified this in our second witness statement.
So
that we made a mistake in the dates. because we didn't have the files.
So just to be clear, what you're saying now, we needn't turn it up. What you're saying now is that between May and September, was it?
Yes.
2019.
Not paid by the claimant in that period.
You were not acting for the claimant, you were acting for D4.
From May 2019 to September 2019, we were doing work for D4. But after September 2019, we stopped work and we represented the claimant only in on December 2020.
Right. And just to be clear, so I know, and then we're not going to have a mini trial about this, but just to be clear of your position now is that in respect of the advice given, summarized in J292, which is where this all started, the email of J292, you gave advice and you were giving it to D4, is that right?
But he did not respond to this particular email. That is why he cannot prove any evidence that we acted upon it.
That's a different question. The question is, in that email, the first paragraph under quote, it says VJ has discussed the matter with a legal firm, Kochar and Co., who have suggested the following. And the question, my question to you is, do you accept that that is advice that you gave to D4 at the time?
No, where is that? Just 1 second, I need that email.
Last page.
J292.
But this isn't a strategy note to
Sorry?
remove file. This advice which he's quoting is in the confidential document which we shared with D4, which is marked privileged and confidential. And the whole purpose for giving the advice was to remove D5, not as alleged by D4 in this email.
We can argue about the content. I just want to know, in respect of those matters, whether you agree with you gave particular advice or not, but in respect of those matters, those were matters that you were advising D4 about.
D4
right?
advice was restricted only to remove D5 from all the entities.
I see. Okay.
That's it.
That's a separate matter. Now, what I'm going to do now is resume Mr. Shaheen.
Actually, incorrect statement made by my learned friend. I thought it's my duty to correct it and point out to the Honorable Court. She said that only from December 2020, Kochar started acting for the claimant. December 2020. The fact of the matter is the case was filed, the claim form was filed on 17th March 2020 by Kochar and Company on behalf of the claimant. So how is it possible that they started acting for the claimant only in December 2020?
I think this is a typo, an oral typo.
Yeah.
So
December,
it was
wait a
December
minute, Mr. Shaheen. I think Mrs. Khan is saying she meant to say 2019.
And we received the documents from the claimant only in February 2020, and we filed on March 2020.
Yeah, so you started acting from December 2019. Okay, that's all been very illuminating. Let's return to the cross-examination.
Thank you.
Your Honor,
yes, of course.
I watched this video. I went back and saw it. It clearly says, look, when ultimately, whether that was a law firm was representing the claimant, and they were actually taking instructions from Kochar and Company. And at that point of time, they clearly mentioned that this was advice given on behalf of the claimant, right?
Yeah.
Now, if these instances, you can go back and talk about archives, you can go and talk about people who have left the company, you can go and talk about, we looked at the timelines. The fact remains that this is an important event which happened in July 30th, 2020. 19, where specific advice, specific means were being sought to break the deadlock. And if suppose somebody was, as they had said on record, that they were representing the claimant, then that means the bank should have been aware of this. And if the bank is not aware of it, and bank is saying that they appointed them under an L1 process only maybe towards the, in 20, January, Feb 2020, then I'm not able to understand, because the whole point is that if the bank was always under the impression that the trade license was intact and all 4 signatories were allowed to operate the account, why did they not allow it? On the other hand, as far as D4, D5 are concerned, there was always bank's endeavor to get signatures from the 2 of them. And we were always under the impression that this amended, articles of association have been brought on at the table, and that is what is creating the deadlock. And after which, you please understand, sir, that this is the whole point of the conflict. It was the bank was not aware. The bank was acting in their minds on the amended memorandum of association. And only later, when the trial process then started and all that, Mrs. Kocher was able to, Mrs. Khan was able to go and tell them that no, the trade license prevails, and actually, therefore, you can make all these people as defendants. So this is the whole point of the conflict, and I'm drawing inference from the pre-trial reference where it is clearly stated on record that they were acting for the claimant.
Mr. Kapoor, I hear what you say. I'm not going to make a separate decision on this at this stage. You can cross-examine on the basis that you consider to be correct, and you can give evidence in your evidence in chief about these matters, if insofar as they're not already covered, because you were entitled to proceed upon the basis of what was told at the PTR, and that's now been altered, if I can put it that way. Mrs. Khan said corrected.
May I also request one more thing? We received their witness statement, and again, in response to that, we also filed our witness statement, which was on the 20th of May 2022. And I don't see that to be part of the trial bundle. It was sent to the registrar, it was sent as a copy to everybody else, and I don't see it to be part of the trial bundle. So if our response has not been taken into account, failing which, what we did is we actually went and filed a complete review petition in which we again summarized the whole series of events and everything else. On which, at that point of time, the registrar sent a summary ruling without giving any reasons, and you kindly requested that we continue with the trial, and then you will make up your mind maybe along with the other facts at the end of the trial. So I just want to put it into context that our response to their 2 witness statements is also there on record. Whether it has been taken on record or not, I'm not sure, because I don't see it in the trial bundle.
It should, Mrs. Khan, I think you're responsible for the trial bundle, so can you please take steps to ensure that it is put there as soon as possible? Thank you. Yes, Mrs. Khan.
I'm told by Mrs. Khan that it is there.
Only they filed it after we submitted it to the court, the trial bundle.
Okay.
The events happened when your witness statements came immediately. We responded to it in the next couple of days. So.
No. 1 second.
Give the reference. 1 second.
I'll find it. I'll find the reference.
We'll just give the reference, your lordship.
If you give the reference, we can proceed for the moment.
The party, if nothing is filed, tell me, I'll do it.
Yes.
Tell him that.
We all heard that, Mrs. Khan. Thank you. We don't need microphones or electronic equipment to hear you.
Thank you.
Right.
Please get the reference. We can help the court.
Sure.
If you can give the reference as soon as you can have it. Find it, Mr. Vajani.
Yes, your lordship. Yes.
Right, Mr. Kapoor, do you want to resume your cross-examination of Mr. Maniram?
Yes, I will in a minute, but I just wanted your honor to take note that I have again endeavored to establish a clear case of information which was available, which was being discussed, which was on one side said it was on behalf of the claimant. Thereafter, the same information is now saying that no, based on timeline, we were actually representing D4 and not representing the claimant. The fact remains, this advice was very much, if not this email specifically, this advice of the amended articles of association was in play. and because of which the bank was insistent on taking the signatures of D4 and D5.
Mr. Kapoor, there's two ways of dealing with this. You can do both of them. You can ask Mr. Maniram questions about it, and you can give, if you want to, give evidence about it in your evidence in chief. But what you say to me here is not part of your evidence. It's part of your argument. So
I understand.
do you want to continue with Mr.
Yes,
Maniram?
yes, I will.
Mr. Maniram, sorry, we've ignored you for a while, but if you're now back on board, Mr. Kapoor has some more questions. Thank you.
Okay, Mr. Maniram, let's continue. Thank you for your patience. We were talking about you not being aware of this email, and we have established that you were not. The next question is that it is correct that the annual renewal of the facility for the year 2018-19, which was done in the early 2019, you had, as per your knowledge, the original mandates had not changed. So that means obviously the renewal letter was sent to all the promoters and all the guarantors. Correct?
Renewal letter sent to the promoters, guarantors, and it is a continuation of the facility which is there from 2014.
So my question once again to you is that during that process of the 2018 December and early 2019, if the mandate had not changed, you should have allowed us to operate the account with the mandates which are still in place. So is that correct?
The mandate, which type of the mandate? Because there is two authorized signatories, was that is what it has been sent to the bank. So the bank was relying on that signatories.
I think it is not about bank was not relying on the signature. I am submitting to you that during the course of those discussions, for every single document, we were looking for a signature from D4 and D5. Never ever was a circumstances suggested by the bank. My question to you is, was there ever a circumstances suggested by the bank that since D4 is not available, or sorry, D5 is not available, or is in India, you have in your mandate two other signatories whom you can seek signatures from? Is that correct?
It is up to the company to take a mandate. If the mandate is available to the company, they would have very well taken the signatories of the other two and submit the transaction request. So it is an internal matter of the company which the bank does not want to comment on it.
So you deny that such an endeavor was not made by the company or by the bank?
By the company.
Okay. So anyway, coming back to the other matters at hand, and let's move on from where we are, because we've already established a few things. Can we also establish that prior to the conflict which started between D4 and D5, when you became aware of the conflict between D4 and D5, both D4 and D5 were actively engaged and involved with the bank concerning the day-to-day affairs, concerning site visits, concerning updates on what is going on in the business?
Yeah, it is already last time I stated in the matter that during the inspection, I found out that the D4 and D5 were in the office along with the team where we conducted our inspection of the unit.
Yeah. I also would like to bring up a point which you mentioned yesterday, which was that you had mentioned in your testimony yesterday that I was out of communication with the bank after May 2019. Is that correct?
Yourself as a D4.
Yes.
D4, yeah. I believe that there should not, there is no, or else I have to check because I'm not sure about it.
I would like to ask this question very explicitly. There was a very clear assertion by you that after May 2019, I was not in contact with the bank at all. This is what you have stated on record.
It is with regarding to the bank pertaining to DIFC branch.
Now we're talking about DIFC branch only.
DIFC branch. If you see from May onwards means it can be in the month of the August onwards. It cannot be directly from the May of the June because the last transaction took place was in the month of the May. You're on mute, sir.
Sorry about that. My question here is it correct that while visiting the DIFC branch, there is a process of obtaining a security pass at the ground floor, which allows you to enter the premises?
A procedure is in place.
Yeah. And I would like to suggest to you that between May 2019 and August 2019, I visited the DIFC branch on several occasions to not only attend the JLMs and engage with the bank officials, which can be verified by the security logs. Would you deny that?
Up to August, you mean to say? From June.
Yeah, up to August, yeah. Because May, June, and July, and August. Because you said after May, I have never come to the bank.
Yeah, after that may be true that after September you are not visited the branch.
Okay. I would also like to suggest to you that the Dubai branch has a reporting line to the international division in Mumbai. Is that correct?
It's a part of the internal process because it has been governed by the policy.
No. I just want to ask a question, please. And if you can kindly answer yes or no, and then you can elaborate. But the DIFC branch reports into the international division, which is the head office in Mumbai.
Yeah, yes.
So, do you agree that Mr. Cherian, who was earlier deposed, in this matter, that and he was also overseeing the affairs of the branch, right? Are you aware that I visited the international division of the bank in Mumbai on 18th November 2019 and was received by Mr. Cherian and Mr. Qureshi? Are you aware of that visit?
That direct communication we have not received from the company side.
Okay.
So
what
date was that?
It
was 19th of November, 18th of November 2019.
Thank you.
In that meeting, are you aware that I reconfirmed with Mr. Cherian my contact details, the Indian contact details, as well as my email address, which had remained unchanged since the last 20 years?
So it was not brought to the notice of the DIFC branch from international division.
Okay. Is it not a normal process that in case any written submission is made to the bank in the Mumbai head office, which concerns a matter pertaining to the DIFC branch, that correspondence would be forwarded to the DIFC branch for their information?
In case if the company would have sent any kind of a letter to the international division, definitely they would have forwarded it.
Okay.
Because if it would have been an oral communication, they might have not accepted it.
Mr. Just one second. I'm sorry to interrupt, but on the 18th of November, I actually submitted a written letter covering the affairs of D1 and some of the other group companies, along with 2 annexures, which was in writing, acknowledged and received by Mr. Qureshi.
It was not a part of the trial bundle or anywhere it was shown. And I am not aware it has been sent to us.
Asking you whether you are aware. So basically, all I'm trying to say is that I was in touch with the branch, and thereafter, when I went to India, I was in touch with the head office, right? And I went and physically visited them. I submitted a written submission with whatever documents, and that did not find its way to the DIFC branch. Is that correct?
Whether any email marked to us in that copy?
It is not an email. It was an actual written submission and a letter formally given to them, and they acknowledged it in writing on my copy.
The post acknowledgement the company should have sent to us so that we could have acted on it.
No. I'm simply asking a question whether you received anything from your Mumbai head office or not.
I'm not sure, sir. It is pertaining to 2019, and I cannot recollect now.
Would you agree that since then and this situation, there has been a narrative about me being absconding, and that is something which has been doing the rounds in the branch?
Yeah, since we could not get the contact over you with regarding to the D1 account, which is there, the account which got an NPA post August, we were trying about, and we could not get your presence in UAE. So even our people have tried, our staff might have tried to go to the house of yours and found that it was locked, or else we could not find you over there. Second comment.
Mr. Manram, my question here is that I visited your head office physically. I submitted a written petition. I re-clarified all my contact details, and I was always available on email. And thereafter, my next question, why did the bank stop sending any email or any update, mark copy of any correspondence relating to D1 to me after the date of August 2019?
You can see even the recall notice has been sent.
Yeah, the recall notice is dated 3rd September. After that, I have not heard any, I've had no intimation, no information on any affairs of D1. So would you agree that the bank sort of stopped treating me as a promoter after September 2019?
So it cannot be. How the bank will treat a promoter out of right, because after the default, there was almost every time there was an approach from the bank to visit the company, which is there as in a form of in a DIC, as well as the what we call the promoters contact available in UAE, in order to get some clarification with regarding to the repayment of the loan.
Right. My last question. While appreciable that D5 also tried to revive and bring new investors, would it be correct to say that the same efforts which were made by me earlier in December 2018 and efforts made by D5 later on, that they were not adequately supported by the bank?
So it cannot be said that the bank does not support it. Bank always wanted to support to then a business entity which is operating. If you see, when there was a no renewal documents, the documents submitted, even the bank took a decision of keeping the account continuity. And it was only the promoters who had what you call, even if you see the net worth of all the promoters was very high, which they could have very easily saved the default happening in the DIC without making the lease payment. I can easily say that to the Honorable, even in the June 2018, there was a sufficient profit in the balance sheet. When the profit was more than what the lease rent was demanding, the company did not make the payment. Likewise, I could just confirm that the promoters were well enough with a good net worth. They could have easily paid the lease rent to the DIC and made the account continuity and the operations of the company.
My last question I had asked, and since you mentioned all this, I will ask one more. At no point of time during the period from January 2019 till the recall notice was sent on the 3rd of September 2019, did the bank ever call for a meeting of all the stakeholders, which is right from D2 to D8, where you could provide a window of hearing the the complete picture, where you could also discuss remedial measures? So why such a meeting was not called for?
I can very well put it in this way. Each and every the overdue letter which the bank has written from the August 2018 was sent to the company as well as the promoters, which they could have easily shared with all the stakeholders of the company, and they could have come to the bank for some kind of a discussion.
No.
The letters are there for
my question is, did you ever call for a meeting of all the stakeholders even once between the period January 2019 till September 2019? Yes or no?
I would like to say that since it is an account pertaining not in a consortium where the other banks are involved.
Mr. I am asking a simple first question. Did you call for a meeting between this period? Yes or no? And then you can always explain why you did.
We did not, but for the better reason that this account was in a partnership company where the promoters were there. It was not what you call the multiple banking facility, where as in a lead bank or in a bank can involve all the stakeholders to have a meeting. So it would have been better the company themselves sent a mail to all the stakeholders stating that we would like to have a meeting with the bank to discuss. That never happened from the company side.
Mr. Maniram, you're a seasoned banker. Are you telling me that only where there is a consortium of banks, such meetings are called for, and otherwise there are no meetings called for any of the stakeholders when a resolution is desired?
It is a consortium or under the multiple banking, regularly the meetings happen. If it in case of a single bank, it doesn't take place.
Doesn't take place. Okay. No further questions, Your Honor. I'm finished with my cross-examination.
Thank you very much. Mr. Vajani, do you want to re-examine?
Yes, I do.
Your Honor, it is a 4 o'clock over here. Right from the morning, nothing was there for me.
Right, is now is time when we normally break anyway. Do you want the long break at this time? Half an hour, 40 minutes?
What is J58?
40 minutes, okay, Your Honor.
Is 40 minutes okay for you?
Yeah, yes, Your Honor.
Right, we'll resume at 12 UK time, 3 Dubai time.
May I, for your Lordship's attention, at least clarify two parts that I need to bring to your Lordship's attention. If
Right.
I now, one is with regards to the information of references which Mr. Kapoor wanted. Both the documents that Mr. Kapoor wanted to refer are in the bundle. The first one is his response to the statement of Ms. Anjali, which is dated 20th May 2022. That is at G357 to G371, and the witness statement filed by D4, that is Mr. Kapoor, on 27th May 2022 is at G378 to G390.
Thank you, Mr. Vajani, for that.
No problem. No problem.
Thank you.
Yes.
Was there another matter you wanted to raise?
Yes, the other matter is, I think we've lost track of time.
Of course.
Fully.
I know that. Let us not take more time discussing that at the moment. What I propose to do about time, because it changes the whole time, we must, at the end of tomorrow, we will see where we've got to, what witnesses still have to be called, and how long we're going to need. Okay, and we can do it at that stage. There's no point doing something now because things will have changed by tomorrow.
That's right. That's right. That's. I'm quite concerned now.
Right.
Thank you, Lordship.
But on that basis, I've really encouraged parties to discuss what if we need an extra 2 days, even 3 days, parties must be able to discuss when they might be available as best possible to suit everyone. But we'll discuss that on Friday afternoon. Thank you.
Thank you, Lordship.
We'll resume at 12:10, 3. Yeah. Thank you.
Thank you.
Yes, Mr. Vajani.
Yes, Your Lordships.
Good afternoon, Mr. Maniram. Mr. Vajani is going to ask. Mr. Vajani is going to ask you some questions now. Thank you.
Yes,
With Your Lordship's permission, may I proceed?
Yes, of course.
Good afternoon, Mr. Maniram. Rather, good evening.
Good afternoon. Good afternoon.
Mr. Maniram, with your experience as a banker of so many years, is it the obligation of the bank to ensure that its customer receives legal advice prior to signing any document?
Legal advice. Yeah, can I get it once again, please?
Sorry, I'll repeat. Is it the obligation of the bank to ensure that its customer receives legal advice prior to the customer signing any document?
No.
May I now request you to go to your second witness statement?
Yes.
And go to page G276. At G276, paragraph 20.
Yes, I'm there.
You have stated over there in the second sentence, extended by the lender at discretion, and you have cross-referenced it with a clause. Could you please clarify the same?
I would say that the limits are continued as long as the borrowers are making the payment, and unless there is a sense, I'll go with that only. The limits are continued as long as the outstandings are there, unless there is an account has become in a default where the bank can exercise the further recovery measures on that particular.
Okay. May I now then request you to go to page G238 of your first witness statement. Paragraph 22.
Yes, please.
You have in the fourth sentence stated, provided the essential review documents. Could you clarify what do you mean by review documents?
The review documents the bank generally takes from the company in order to review the accounts, which is the financial audited statement of the company, and what are the present net worth of the promoters or the stakeholders of that company, and other documents like any projections for the future sales, future projections, so that the bank can assess on that and do the review of the account for the next 1 year. That will be in line with the continuation of the limit of the original facility agreement.
Mr. Manira, may I just request you to answer a bit slowly so that it can get recorded properly. In the same paragraph, further, if you go to the last part of that paragraph,
yes,
second last line, and a lender might be at the risk of incurring liability in damages for breach of contract for refusing to lend. Could you please clarify the same?
It's a case that if the liabilities are not paid by the borrowing company, definitely the lenders are at the risk of getting their money back. Or else should I further any explanation required?
Mr. Maniram, I think the question was about the risk of incurring a liability and damages for breach of contract. How does that arise?
The risk of incurring the liability to the bank occurs in case we are not continuing the liability, a renewal of the limits, and the future receivables which is going to come from the company, if doesn't come to the bank, there is a risk to the bank. So our outstanding will be at a risk.
With your lordship's permission, may I put the same question again?
Yes.
Mr. Maniram, if you read the last sentence, it talks of the lender facing damage, liability, lender facing the risk of incurring a liability in damages for breach of contract for refusing to lend. What does this mean?
If suppose the bank does not wanted to lend in the sense in the continue the TR facility, there is a risk for it. So in order to stop that, there is a review of the limits as undertaken by the bank.
What is the purpose of the review that you are referring to in paragraph 22?
The purpose of the review is to keep the account availability of the facility to the borrower until the account not become an NPA.
What do you mean by renewals?
Renewal, in the sense, it is nothing but in a review of the account for a particular period. It may be for 1 year, or there may be a period of a short review for 6 months.
You have in this very paragraph at the second last sentence said had to review the facility agreement, failing which such a lender might be at the risk of liability. Could you clarify why you had to renew this facility?
This facility, since it is the facility drawdown for what you call onboarded from the February 2014, so it is a continuation of the limits from 14 to 16, 16 to 17. So the review is happening on the basis of the master document of 2014 on subsequent amendments to the facility agreements.
Now, may I request you to please see I-3094.
Yes, I am at that page.
This letter was shown to you earlier. My first question would be, did you receive this letter?
Yeah, it is received in the banks.
Does this letter in any way request for reduction in the TR financing?
Existing 5.5. Yes, there is a reduction in the TR facility.
Would a renewal or a sanction letter be required if there was a reduction in the TR facility?
Sanction letter is required, the same as being provided to the company with a reduction in the limit.
Is the bank obliged to accept the request of increasing the overdraft from 0.5 to 3.00 million US dollars?
The bank is not obliged for it.
Was any overdraft limit increased in the January 2019 sanction letter?
1 second. No, January 2019, it was kept at the 500,000. No, I would say no.
May I take you to I3106?
Sorry, what page is that?
Your Lordship, I3106.
And
Would your Lordships have?
Yeah.
yes.
Mr. Maniram, does this reflect the acceptance of the request by the company in the TR facility?
Yeah, this, no, it is a TR facility. The company requested, 1 second. Company requested for a 3 million. Yeah, it is as per the company's request, TR facility is 3 million.
Why was the existing facility reduced from 10.94 million to 3.93 million?
One is the company itself has given a request for the reduction, and there was no utilization of the term loan 4, which was earlier sanctioned. And whatever the projections was given for an increase in the limit of 10.94, which the company has not done that kind of a sales. And there was a subsequently request letter from the company in the December for reduction. So overall, it is a review done by the bank to see whether the utilization is there in the existing limit. If there is no utilization, the bank can take as the letter was being given by the company, there is a reduction in the limit.
When you issued the 5th January 2019 sanction letter, were the term loan 1 and term loan 3 overdue?
So there is no mention in the sanction that overdue is there in this one. Only the TR facility may be overdue.
Mr. Maniram, can I take you to the I3085?
Yeah, I'm at that page. 3085.
Can you please see the statement after the table?
Also, there is an audio. Yeah, it is there, as it is mentioned by an email. So, yeah, I can take it that there is an audio even in the term loans.
Thank you. With regard to the discretion of the renewal and the ongoing review, can any discretion of that nature be exercised once the asset, that is the account, is classified as an NPA?
No, if you can just, should I explain?
If you want to.
So once the account become an NPA, the bank starts the recovery mechanism so that the bank can get the liability which is outstanding in the borrower. They can recover from the borrower and adjust the loans. So the prime duty will be for the bank to recover once the account has become NP.
Maniram, Your Lordships, I have about 15 to 20 documents to be referred cumulatively, and then a question be asked. How would I present it to the witness? All of them reflect and talk of the same thing. For the benefit of the court, can I just give the numbers for identification? And it can be taken that those are the communications addressed by the bank to defendant number 1 and the other defendants, if any, for the purposes of notifying the overdue defaults and the renewal defaults. So there is,
Give us your list of references.
yes, the list of reference would be I-2936 dated 26th of August 2018. I-2937 dated 16th of September 2018. I-2938 dated 17th of September 2018. I-2939 to I-2942 dated 17th of September 2018.
17th.
Yes, Your Lordship. I-2955 to I-2956 dated 25th of September 2018. I-2957 to I-2962 dated 9th of October 2018. I-2963 again dated 9th of October 2018. I-2964 to I-2965 dated 14th October 2018. I-2966 also dated 14th of October 2018. I-3009 dated 15th of November 2018. I-3085 3085 dated 21st of November 2018. I-3100 to 3105. That's between the period 3rd of January to 15th of January 2019. I-3116 to I-3136. That's 16th of April 2019. And I gave these references together because, Your Lordships, they are clubbed together. However, the earlier dates are subsequent documents also. So that is I3146, which is dated 14th of January 2019. Is Your Lordship saying something? I'm losing some voice.
No.
I148 to I149, dated 20th of January 2019. I3150 to I3151, dated 23rd of January 2019. I3152 to I3153, dated 27th of January 2019. I3154 to I3156, dated 28th of January 2019. I3168, dated 2nd of April 2019. I3169, dated 7th of April 2019. I3173 to I3175, dated 16th of April 2019. I3188, dated 2nd of May 2019.
What was that last date?
2nd of May 2019, Your Lordships.
Right, what's the question?
I seek Your Lordship's pardon for this cumbersome list, but I just wanted to put all of them together, that this is a series of correspondence, and if the Honorable Court and the witness can take it, which relates to the intimations by the bank with regards to the default of overdue and the default of renewals.
Intimation by the bank of
the overdues from time to time.
Yeah. And
which were under default from time to time, as well as the default with regards to the renewals.
do you have a question for the witness?
Yes. Mr. Maniram, despite these communications or reminders, as well as the cooperation by the bank, were the defaults cured for a period of 15 months?
Out of this, if you can take for the pertaining to the August, September, previous months, till the time that excluding that 4.
First, please answer yes or no.
I'm not sure I understood the question.
The question, Your Lordship, the question is that despite these letters and reminders, as well as the cooperation that was extended by the bank over this period of 15 months, was the default cured by the defendants?
No.
Do you mean the first defendant?
Yeah, first dependent. The borrowing company has defaulted they had not cured the account.
Yeah. You see, Mr. Vajani, I interrupted there because you said the defendants. I think you meant the first defendant, did you?
Yes, yes, Your Lordship.
Right.
Anything I can say, sir?
If you want to.
This is I can put it in such a way, sir, Your Honor, that there is a regular communication from the bank to intimate the borrowing, the D1, that there is a default in the payment of the TR receipt. There is a due in the amount of the term loan. So let them pay on a due date. And it was an intimation clearly giving them to update the account and improve the status of the account so that the continuity of the business will be there.
Right.
Sorry. Ms. Maniram, anything else? May I ask the next question, please?
Of course.
Sure.
Mr. Maniram, can you go to I-2975? Your Lordship, this is the memorandum dated 15th November 2018.
Yeah.
At I-2976, if you see a table below 2.3.
2 point. 2 point, please.
3.
2 point, yeah, I'm
In that table, at 2.4.7, it is written SMA2 on account of non-renewal of the facility. My question to you is that if D1 was SMA2 on 15th November 2018, why did it not slip into an NPA immediately thereafter?
In this case, we can say, I'll say that since it is a SMA2 under the non-renewal, it is not an financial default. It is a renewal and review and renewal default. So the time period for the review and renewal is more than 6 months, whereas in case of the financial default, it is 90 days. So in this case, the account was not declared as a NPA immediately as it is in the month of March 2019, I can say.
Mr. Maniram, during your cross-examination yesterday, you were asked about the bank stepping into the shoes of D1 with regard to the plant and machinery. My question to you is, why did the bank not step into the shoes of D1 with regards to plant and machinery? Sorry, Mr. Marina, 1 minute. Mr. Shaheen has something to say. 1 minute before you answer.
Mr. Shaheen.
Yes, it was not stepping into the shoes for the plant and machinery. It was
for the building
of the lessee. It was stepping into the shoes of the lessee under the assignment of lease. That question and answer are being misquoted.
Mr. Vajani.
So my assumption was it was with regards to all the assets that was being asked. So I had broken it up in 2 parts, which is plant and machinery and the DIC, because DIC is a different asset. But if my learned friend says that there was no question with regards to plant and machinery, I am willing to drop that also.
Yes, Mr.
I did not say there is no question regarding asset, plant and machinery. I said step into the shoes was with specific reference to the lease agreement.
No, I think you should ask the question as you think. I don't think there's any significant difference between you, but I'll ask your question.
I'm deeply obliged, Your Lordships. I'll leave the history behind and ask you a plain question. Why did the bank not step into the shoes of D1 with regards to plant and machinery?
Regarding the plant and machinery, the payment was due to the DIC, where the account was already declared as an NPA. The system was not in a position to make the payment to pay the lease rent for that. And moreover, with regarding to stepping in, it is the prime duty. I would say that it is a prime duty of the borrowing company to keep the plant and machinery at their premises, so that whatever the dues are there in a form of an insurance, lease rent, and upkeeping, it lies on the D1, that is the company.
May I take you to H5 to 8?
Yes, I'm at page.
This is the mortgage over movable properties, movables.
Yes.
And if I can take you to page H532, sorry.
352.
532, sorry, my apologies, 532.
Yeah, I'm at that.
Could you for yourself just read clause 6? Just read it for yourself.
Yeah.
Thereafter, please read clause 8 at 533.
Clause
8.
Yes.
In the light of your earlier answer, just before I showed you this agreement, and in the light of the clauses that you have read, I'd like to ask you a question with regard to an answer you gave yesterday, where you mentioned and where you said as to that it would be the obligation for the bank to secure the mortgage property. Why?
Yesterday, it was the mention that right from the beginning that the account has become NPA. It was not an obligation on the bank, so it was not accepted. Or anything further should clarify.
What was not accepted, Mr. Maniram?
Stating that the bank is not in a position or cannot enter into the shoes of the lessee.
Who communicated to you that that was not accepted?
It was yesterday's during the discussion with the council.
I believe the council was only asking you a question.
Yeah.
I will therefore now once again repeat the question. Why did you mention yesterday that it was the obligation for the bank to secure the mortgage property?
It was not the obligation on the bank. It was been put in my words saying that it is the obligation of the bank. Whereas my contention was that it was the prime duty of the company, the mortgager, the company to keep the upkeep of the property which is been mortgaged to the bank. If the bank doesn't have the obligations on it.
With regard to the DIC property, which was assigned to the security agent, was a lease rent ever paid by the bank?
So it was it was directly paid by the company itself from their own internal sources, or it may be through the request. But the bank has never made a payment directly.
Could I request you to see I3083?
I3803.
3083, please.
Please.
3083.
Sorry. So it's taking to the financial statement of the company.
I3083 is an email dated 20th of November 2018.
Yes, I'm at that place.
Would your lordship?
Okay, I've got it. Yeah.
Could you please clarify this email, Mr. Maniram?
This is with regard to the plant and machinery, where we wanted to change the security agent from National Bank of Oman to Bank of Baroda, since the charges are within the from USD 15,000 to 15,000 dirhams. So it was in the benefit of the bank as well as benefit of the customer to get the cost reduced.
Then could I take you to I3319?
Yeah, I'm at that page.
I'm not.
I take you to an entry which is dated 9th of April 2018.
Hold on a sec.
Yes, Your Lordship.
3319.
That's right, Your Lordship.
Right, okay. Entry date of what?
9th of April 2018. There's only one entry dated 9th of April 2018.
Yes, please.
One sec. Let Your Lordships have that entry.
I have it.
It reads security creation of P&M 20,000. Mr. Maniram, can you please explain this entry?
It's a debit entry to the account of the company where we are making a security agent payment for the national for the previous financial year pertaining to the National Bank of Oman.
This is in relation to which property? What asset?
In related to the plant and machinery and of the company, which is the D1 scope.
If you had paid the security agent on 9th of April 2018, why did you not pay the lease rent in respect of the DIC property when the problem arose?
The problem notification, if you see the DIC's request came somewhere in 2020, for 2020, maybe September or August, where the account has been already classified as a non-performing asset. The bank as a legal department and recovery department has initiated the recovery measures on the company to get back the get the loan back. So in that circumstances, the system which is being followed in DIFC, where it has been regulated, we are not supposed to make any further debits to the account. The system will not permit. So in that circumstances, we were not in a position to make the payment to the DIC.
What was the annual rent payable to the DIC?
Just see into the system, because it is a totally approximately it will be near about 580,000 dirhams.
During your cross-examination, you were informed by my learned friends that the value of the property was 3.4 million USD. Could you clarify with regard to the same?
That is, I can very easily. It's as per the balance sheet of the company that the value has been arrived. And in the real circumstances, if you see, the investments are there on the land and building of the company. The land is pertaining to the DIC. So the infrastructure which is created on the DIC has a value which cannot, it is one value of a land and building, and rest is the plant and machinery. So it is a combination of land and building and plant and machinery, that value.
Could you have ever dealt with the land which is owned by DIC?
No, it's generally the companies which deal with the DIC. They undertake a lease for a period and subsequently do the constructions over there in the form of a building, and then the installation of the plant and machinery takes place.
Assuming, like my learned friend on the other side stated, that you could have stepped into the shoes of D1 with regard to the property at DIC. My question is, would you have dealt with that property?
No, bank, first of all, the bank has to take a legal course to get the judgment in the bank's favor. And subsequently, only the bank can put for an auction. It is a long measures or a long sequence of events. By the time when the bank wants to get put to the auction, the value of the assets which is there in the form of a land, building and plant and machinery will definitely depreciate, and the recovery through that measure will be much lower, or it will not match to the extent how much the outstandings are there.
Could I now take you to page F159, Foxtrot 159.
159, just I think the next link which I got it, I have to see in the other PC. F159. Yeah, I'm at F159, please.
Sorry, 158 and 159.
Yeah.
Can you please go over that?
Yeah, I'm at that page, sir.
Could you confirm that this email with regard to the amount due to DIC?
Yeah. This DIC, we have sent an email stating that the bank has taken up the matter, which is there.
So this is with regard to the amounts due to DIC?
Yes, it is.
If I can take you to one more page before, from where it begins, is F157.
157. Yes, I'm at that 157, please.
Now, 157 was responded to by you at 158.
Yes.
Wherein you have stated that you have taken up the discussion with the company and personal guarantors to make necessary arrangement.
Yes.
Did defendant number, your email is also marked to D4, D5, D6, and D7.
Yes.
Did these defendant numbers or the guarantors D4 to D7 revert to you with the required payment?
No, they did not.
Could you please clarify why?
The payment request, it is from the bank side. We have sent to all the partners, the promoters, as well as the guarantors, so that the assets which is there in the company in the form of a land and building and plant and machinery can be saved, and they can continue do the business. And it was the prime duty. It was the duty of the promoter company to safeguard the assets, which is mortgaged to.
Just for your lordship's reference, this document, I'm not showing separate emails because this whole series was culled out and put in the RFI that was received. So I thought I could show this entire series in one place. That's why I refer to this bundle F.
Mhm.
Mr. Manda,
Yes, please.
may I now take you to your witness statement G240?
Yeah, I'm at.
At paragraph 30, you have enlisted 4 TRs which remained unpaid.
Yes.
Are there any other TRs which remained unpaid?
No.
Maniram, I will now take you to H394.
H234
H394, your lordships.
394.
I'm at H394.
Would your lordships have it?
Not yet.
You go over clause 26.1.
Hold on. Right.
Maniram,
Yeah.
is fax a permitted mode of communication with regard to the finance documents?
Yes.
Sorry, did you say H394?
Yes. H39.
And what's the question about?
I was asking him a question in relation to 26.1 as to whether fax was a permitted mode of communication
I
with
see.
regard to finance documents.
Yeah. Yeah.
Mr. Maniram, now may I take you to I2935.
Yes, I'm at I2935.
Would your lordships have that letter?
Yes, I do. Yes.
That is a letter addressed by Mr. Ravi Kuchumachi.
Yes.
After receipt of this letter, what action did the bank take?
The bank was accepting the TR request duly signed by full original signature of the D5 along with the D4.
Maniram?
Yeah.
After 15th August 2018, how many transaction requests or utilization requests were received by the bank?
Five, approximately it should be 5. If I see this one, 4 are the pending and the other one, 5 it should be.
Did you offer the defendants to inspect the original TR requests or the utilization requests?
The claim from the claimant side, it is open for all the defendants to accept and to view the original TRs, and the same is being provided to the counsel also, the claimant's counsel, for producing to all the defendant counsel.
Would I take you to paragraph 26 of your second witness statement, G278?
I'm at this G278, please.
And also parallelly with it, please go over paragraph 26 because I'll have to take you to another document and then ask you a question. Would your lordships also have G278 paragraph 26?
Yes, I've got that, yes.
Yes. Mr. Maniram, let me know when you're ready.
Yes.
Thank you. May I now request you to go to bundle F, page F155, which is also again the RFI response.
F15.
151.
155, your lordships.
155. Yeah.
Yes.
At F34, where it reads that the defendants were offered to come to the claimant's counsel's office to take inspection of the utilization requests.
Yes.
Did any of the defendants avail the inspection offered?
As per the bank, I have not received the communication, and I believe they have not visited the branch.
Have they visited your counsel?
No. The message from the branch is no.
After the 15th August 2018 letter, which you saw, which was received from D5, was there any forensic document examiner or handwriting expert appointed by D5 for the inspection of the signatures on the transaction receipts or the transfer receipts or the utilization requests?
No. I have not sure. It is no, because I have not seen any forensic audit expert visited the bank. No.
May I now request you to go over to I2968.
One second. Yeah, I'm at I2968, please.
And you can go, your lordships have that?
Yes.
This is the utilization request form and the utilization notice, and this entire bunch of this transaction would go up to I2974.
Yes, I'm.
My question to you is the first one. Is this the first utilization request that came after the letter of 15th of August 2018 from Difc?
Yes.
How was this utilization request received by the bank?
But this transaction is already paid by Your Honor, and it might be received in a form of original or fax. I'm not sure, but this transaction is already the paid one.
What do you mean by paid?
It is not a case of a default or overdue. This payment we have received, the bank has received the payment, and there is no overdue in it.
Was this TR cleared?
Yes, TR cleared.
May I then take you to I3087?
308.
7.
Yes.
This utilization notice, your lordships has 3087?
Yes.
This is a utilization notice, and the entire bunch would end, as far as this transaction is concerned, at I3093. This is again to the same entity which was in the previous transaction in August, in October.
Yes, I'm at page.
What's your question?
Yeah. How was this TR received?
This TR original in a form of original received at the branch, and subsequently the transaction got executed.
Has this TR been cleared or is it in default?
It's a default. It's not paid.
May I then request you to go to I3160.
I'm at page I3167.
Yeah.
The Russians may be. This is dated 13th of March 2019. Again, a utilization request. And this bunch for utilization in favor of Signalia General Trading Company LLC would end at I3167.
Yes, I am at.
Maniram, how was this TR received?
They are received originally and signed by the partners, and it is a signed. It is a signed copy received by the bank as per the instruction given by earlier letter by the D5.
When you say signed, you mean by a pen, ink?
Yeah, pen. Original signature is there. It's a ballpoint pen, we can say.
Could you read the endorsement made in hand?
Yeah. Dear sir, please release only USD 90,000.
For yourself.
Done, sir.
And could you also read the endorsement made in hand at I3162?
Yes.
Do you have a question arising from that?
Endorsement. Sorry, Your Lordship, I was saying something.
I don't know whether you were talking unmuted, but you asked the witness to look at the handwriting,
Yes.
and you didn't ask anything else.
I wanted to ask him the question now, after he would confirm, as to who has made this endorsement.
It is by Ravi, D5.
Did you receive this with the endorsement, or the endorsement was made at the bank?
With the endorsement we have received in the original form.
Was the payment made as per the endorsement of D5 or as per the utilization notice?
As per the payment request, as per the instruction given by the D5.
Mr. Maniram, please clarify if the payment was in the sum of US dollar 90,000 or the payment was in the sum of US dollars 237,000.
It was in the form of US dollars 90,000, and the same is as stands today also as a default.
You've saved me from the next question. This term, this TR remains unpaid.
True.
Mr. Maniram, may I request you to then go to 3180.
Yeah, I'm at page 3180.
It is again a TR request to the same entity as was in the earlier one.
Yes.
How was this TR received? Sorry, Your Lordship, this bunch of transaction will go up to 3187.
Yeah.
Yeah.
Madam, how was this?
The branch received the original set of the request from the company, duly signed in a ballpoint pen by the partners, managing partners. D4 and D5.
Was this payment made as requested?
Payment made as requested by both the parties. Yes.
Has this TR been paid by the client?
No, it's outstanding overdue.
May I now request you to go to I3189. This transaction is again in favor of the same entity as was in the previous two entities, and its documentation goes on up to 3196.
Yeah.
Was this, how did you receive this TR?
Here received in a form of original, and the copy is available at the branch.
Maniram, this TR is signed by only one partner, director.
Yes, it is one partner. The other partner, D5, he was supposed to come to the branch for signing, which subsequently not happened.
Was this transaction made?
Yeah, transaction made. And I would like to clarify with regarding to this company. This company is a tested company where we are doing the payments from the bank side from 2015 onwards, 2015 August onwards, and almost 3.5 million might have been done. And it is a regular customer of the borrowing company where they procure the goods and process the goods and subsequently sell in the market. So it was the D5 was about to come to the branch and put the signature, which not done.
Did D5 send any written objection after the transaction was done?
No, we have not received it.
Mr. Maniram, the last 5 transactions that I showed, as well as the transactions which happened right from the year 2014 in regards to the TR receipts, were the monies transferred directly to the customers or routed through the account of B1?
It is routed to the account. It's a practice that it will go to the current account, and from current account it goes to the respective beneficiary account directly to the beneficiary for making the payment. So,
Ms. Maniram, during your cross-examination, you also confirmed that the renewal in the year 2015 was not signed. Correct?
yeah, it was not signed.
So remind me which year that was.
2015, Your Lordships.
Yeah.
May I take you to I114? And 115. This is dated 4th of February 2015.
Yes, I'm at page.
Your Lordships have that.
Yeah.
And I222. Sorry, I233. Sorry, my apologies. I233. Going up to I-236. Dated 7th July 2015.
Yes.
And then I-597.
Yeah, I am at.
Going up to I-600. This is dated 29th of December 2015, the last of the transactions in the year 2015.
Yeah.
My question is, if the renewal letter or the sanction letter was not signed in the year 2015, on what basis were these TRs accepted and honored?
The request is there, which shows that the company has requested, and the continuity of the term facility, as per the term facility agreement, the continuity of the limits was available to the customer for availment, and there is a balance availability was there in the account. The limit was within the.
Sorry. Completed.
The outstanding was availability of the funds was there in the account, and there was a continuity of the facility, and there was a request from the customer in even after the not accepting the sanction letter, not signing the sanction letter. So it's the continuity of the limit clearly shows that TR payments has been done as requested by the partners.
Was the same principle followed up to the last transaction on 20th May 2019?
20th. Yeah, last transaction 23rd May. Yeah.
30th May.
Same. It was followed in the same way. The continuity of the limits, since the limit was available, and the continuity of the facility was being provided.
Mr. Manira, can I now take you to your witness statement, the first witness statement.
Yeah. Page
243, paragraph 38.
Yes,
May I request you to go over the same? Would your lordships have that paragraph?
Yes, I do.
Yes.
Mr. Maniram, did you calculate the interest manually?
No, it is a system driven. It is as per the DIFC. We have adopted to the regulatory which is there in the form DFSA regulatory, and it is a system driven. It's in the form of the core banking solution in Finacle. So the systems are calculated as the contractual rate given to the customer.
Maniram, the interest which is calculated in this paragraph and reflected by you in different figures is as per the facility agreements?
Yes,
which point
you say it's a leading question, do you?
Which point?
Yeah. Well, I think if you can ask it in a non-leading way.
I will endeavor anyway. This is the last question. I didn't give my learned friend too much chance to complain this time. This is the last question. Are the interests in this paragraph all contractual in nature?
Yeah, it is as per the contractual in nature, which was given in a form of an FS, in a form of a sanction letter to the customer stating what is the rate of interest.
Have penal interest and default interest clauses been included in the facility agreement?
Yeah, it is a part of the facility agreement, and the same contractual rate is mentioned in the sanction letter.
Is there or it isn't, Mr. Shaheen? There's no point worrying about a leading question on that.
Yes.
Yes, sir. I've been very tolerant. I will restrain myself to the maximum, but continuously asking leading questions. That's why.
I'm sure you've restrained yourself very well. Thank you.
I rest my case, Your Lordships.
Yes, well, that was a very long 10 minutes.
I couldn't help because the 30 minutes went on for almost 24 hours. I would see Mr. Maniram went into the box yesterday. And
No, I was thinking the agreed timetable was 10 minutes for re-examination.
I know. But I couldn't help because I had to cover a lot of cross-examination, which was only 20 minutes and 30 minutes.
Mr. Vajani, I'm not saying this by way of criticism because this case has taken the time it takes, but it just shows that it's dangerous to make assumptions about timing until we finish the evidence this week.
Which is what I forewarned Your Lordships before we broke for lunch. That's the worry.
Mr. Maniram, that's the end of your evidence. You're free to go now. Thank you very much.
I'm really thanks, Naida. It was the first time given an opportunity and experience to speak to my lord and all the council. I feel excited and honored and pledged and obliged to be a part of witness statement. Thank you, Your Honor. Thank you.
Thank you very much. Goodbye.
Thank you.
Bye. Now, Mr. Vajani, that is the end of the claimant's factual witness evidence, is it?
Absolutely, Your Lordships.
Right. So according to my note, the next person lined up is Mr. Kapoor to give evidence, but is that agreed between everyone?
Yes, Your Lordship.
Yeah, right.
The only change that we have in the agreement is that since the interests of all the defendants against the claimants are aligned, the claimant will cross-examine each of the defendants' witnesses after the defendant counsels have cross-examined them.
Is that agreed?
That's not agreed, I'm afraid. No.
That's something which is not agreed.
Can I speak, Mr. Bajani?
Sorry.
That's not been agreed. And I would object in strong terms to the claimants going last. This is the claimant's case. This is the trial of the claimant's claim, and they should be cross-examining the defendant witnesses first. And so we do not agree to the claimants cross-examining defendant witnesses last. It's as simple as that.
Mr. Shaheen?
It was never even discussed, and I fully agree with my learned counsel. There are conflicting interests and additional claims between the defendants. It's not possible. It's not correct to say that all the defendants' interests are aligned. It's an incorrect statement.
Yes, I think if it was a case where all the defendants were taking a straight defence to the claimant's case, then there would be some force in that, Mr. Vajani. But there are conflicts between the defendants.
May I be permitted to explain a point to Your Lordships?
Of course.
As far as the claimant's claim is concerned, they have been unequivocally denied by each of the defendants. There's no doubt that they are each of them denying that there is a claim which is sustainable made by the claimant. To that extent, all of their interests are aligned. Alternatively, they have an inter se allegation amongst each other that it is your responsibility or the other's responsibility is something which is very distinct in any event. And that is why I cannot afford to have a situation where I would have cross-examined Mr. Kapoor, for example, and then that cross-examination is undone by several questions by the other defendants whose defense, at least as far as my claims are concerned, are aligned. They have joined hands with each other as far as the claimant is concerned. They don't say that, yes, the claim is right, but it is not my responsibility, it is the other's responsibility. They unequivocally all say that the claims are not right. And therefore, it would be completely right in terms that I go last and the defendants cross-examine them first. I'm not going to ask them questions with regards to their inter se dispute because I'm not interested. I have made a claim against all of them. But if I go and cross-examine a witness, that can be certainly undone by the defendant counsels, because if I have asked him questions with regards to the claim, they would certainly be entitled to then ask him anything, which would not be fair fair to the claimant. Because they don't say that, yes, the claim is accepted. Neither of them have said it.
And, do you want to add anything, Ms. McGlone?
Well, I've explained our position. This is the claimant's claim. I don't necessarily accept Mr. Bajani's characterization of the different defendants' cases. Their additional claims are as against each other. They're not as against the claimant. We're not in a situation where we've got a counterclaim, which could be infected, for want of a better word. And I simply would maintain that in the usual course, it would be for the claimant to cross-examine the defendants first, the defendant witnesses first of all, and there's no reason for departing from that in the present case. And I simply maintain our objection to anything but that usual order.
I think the usual rule ought to apply, and we have the cross-examination by the, unless agreement is reached otherwise, which it hasn't been in this case. It's quite common for agreement to be reached, but if it's not reached, then we adhere to the correct order, which be the claimant going first. As between the two lots of defendants, I don't know whether you two have agreed who goes first, Mr. Shazeen and Ms. McGlone. Is one of you going before the other? If there's no agreement, we'll go in numbers.
I had rather envisaged that Mr. Shaheen would precede me on that.
Yeah. Well, you're the second and fifth, so I suppose that makes sense, Mr. Shaheen. All right. Very well. So we'll do that. Now, is everyone happy to start straight off, or do you want 5 minutes to regroup?
We'll take a 5-minute break, Your Lordship.
5 minutes enough? Yep. Take a 5-minute break. Thank you. Is everyone here who wants to be?
Yes, Your Lordship.
Yes. Very well. Mr. Kapoor, do you want to affirm or do you want to take the oath?
I would go for an affirmation, Your Honor.
Maitha, could you administer or take the affirmation, please?
Yes. Yes, Mr. Kapoor, can you please repeat after me? I solemnly declare and affirm
I solemnly declare and affirm
that the evidence I shall give will be the truth,
the evidence that I will give will be the truth,
the whole truth, and nothing but the truth.
the whole truth, and nothing but the truth.
Thank you.
Thank you very much. Now, Mr. Kapoor, how are you going to do this? As I see it, you have submitted 10 witness statements.
Yes, Your Honor.
Do you want to simply adopt them, or do you want to amplify any aspect?
I have made all the witness statements as to the best of my knowledge and ability, but in case there is any specific question, I may have to amplify it, which may not have been specifically covered in the witness statement already.
No, it's not for me to try to get you to amplify it, but if there are anything in your witness statements that you want to correct or draw attention to, then now is your opportunity before you're cross-examined. Do you understand?
No, I'm fine with that, Your Honor.
Right. I think we should formally see which witness statements are going to be part of your evidence. Are you relying upon all of them?
Yes, Your Honor. And my only question to you would be that in my case, since I'm actually representing myself, how would the reaffirmation happen?
The re-examination.
Sorry,
Well, I think in principle you can go through in re-examination elaborating on points where you don't think you gave a sufficient answer or it wasn't clear. But in practice, I suspect you will give a sufficiently clear answer in the course of your cross-examination that you will not need to re-examine yourself. But if there's a point that occurs to you you should have made or you didn't make clearly enough, then make a note of it and you can bring that out in re-examination. The re-examination is really just for clarifying matters or explaining further, or if you didn't feel you had an opportunity of giving a proper explanation. So what we ought to do before we start the cross-examination is to identify formally the various witness statements you've made. Do you have them all in front of you?
Yes, Your Honor.
Perhaps if I go through them for the sake of ease of identifying, what I've called number one is a witness statement dated. It's not dated. It's a G118.
Yeah, I have it in front of me.
What date is that witness statement? I don't think it has a date on it.
It does not have data. It's 30th November.
It was 30th November, I think, 2020.
Right. And is that your signature on the document?
Yes, Your Honor.
Perhaps I should ask you this. I'll help you in an examination in chief just to this extent. That it's your signature, and is that statement true?
Yes, Your Honor.
Right. I hope parties don't object to me dealing this way, because I think we ought to formally get the statements before the court. Your next one, Mr. Kapoor, is G149. Tell me if I've missed any out, but I don't think so. G149, second witness.
Yes, witness statement, yes.
And does your signature appear on each of those pages?
Yes, Your Honor.
Again, I don't think we have a date, do we? It's 31st December 2020.
Yeah, that's right.
And is that statement true?
Yes, Your Honor.
And now's your opportunity. If with any statement you want to qualify something or explain something or change it, now's the chance as we go through them. Your third witness statement is at G156.
My apologies to interject, Your Lordships.
I can't see. Hang on a second. I've got a screen is blocked by witness statement. Yes.
My apologies. I just wanted to reconfirm if Your Lordships got the date of the second witness statement right, because that's available at G159 and it's 17th of January 2021.
No, I'm looking at the one I was looking at. Well, hang on one second. Was Also G149.
G1.
And the date was at one. The date was 153, 31st December 2020.
That's right. That's right.
Right. Your third witness statement is at G156.
That is correct.
And again, your signature appears on each page. Is that right?
That's right, Your Honor.
And that is 17th January.
Right.
2021. And is that witness statement true?
That is true.
Your fourth witness statement is at G162. And it's dated the 27th of June in the top right-hand corner, 27th June 2021. Is that right?
That is correct.
And is your witness? I don't think you signed each page. It's very short. You signed the second page.
Yeah, because it was very short. I think that's why I just signed the last page.
And is that witness statement true?
That is true.
Number 5 is at page G171, dated 9th of September 2021. Is that right?
That's correct, Your Honor.
Again, I don't think you signed it, but you signed the second.
Yeah, I've
signed the last.
End of the statement, last page, yes.
But is the whole of the witness statement true?
That is true.
Your sixth witness statement is dated the G173, dated the 23rd of September 2021.
That is correct.
Again,
I've signed it at the end, yes.
Signed at the end. Is that statement true?
That is true.
Your seventh witness statement. Sorry to take this slowly, but I think we ought to get it in the record. Is a G193.
That is correct.
Dated 24th November 2021. Sorry.
That is correct.
And is that statement true?
That is true.
Your eighth witness statement is at G324, dated 29th of April 2022. Yep.
Yes.
And is that witness statement true?
That is right. So 8th. Then the 9th is, I think, the
ninth witness statement is at G357. This is the one we couldn't find until this morning. And that's dated 20th of May 2022.
That is correct.
And is the witness statement true?
That is true, Your Honor.
And your last one, the 10th, is dated 27th of May 2022. And again, is that true?
That is true.
And you would like those statements to be taken as part of your evidence?
Yes, Your Honor.
Very well. There's nothing you want to add at this stage before being cross-examined?
No, Your Honor. I'll take the questions as they come.
Right. Very well. Thank you. Mr. Shaheen.
Your Lordship, I see a seventh person with the video on the screen, but the screen is blackened. I would like to know who it is.
I can't. How do you ask about a blank screen?
Disappeared. It was shown Kochar and Company. The person appeared twice, but then the screen was blackened.
All right. Are you happy now? Thank you. Mr. Virjani, it's your cross-examination.
Your Lordship, we have, I'm sorry to interject, but the screen should be on because my team who's taking down notes inadvertently switches on the camera despite telling her not to do it.
Right.
But
Okay.
generation.
I'm sure you'll keep control.
I will.
Thank you. Mr. Virjani.
Yes. Good evening, Mr. Kapoor.
Good evening, Mr. Virjani.
Kapoor, for the record, could you state your full name?
Vijay Kapoor.
What are your qualifications, Mr. Kapoor?
I am a chartered accountant.
For the record, could you state your professional background?
I have, after qualifying as a chartered accountant, worked in various organizations, mainly banks, and 11 years in India and then 11 years thereafter in Dubai, before starting this own companies in Dubai.
Could you tell us more about the companies that you dealt with at Dubai?
I'm sorry, come again?
Could you tell us something about the companies with which you dealt at Dubai?
I joined Emirates Bank in the year 1999, then moved thereafter to Bahrain for a brief period, then came back to work in the DIFC with a company called Forsyth Partners. After Forsyth Partners, I worked for First Rand Bank, and thereafter I moved out and started being on my own.
When you were on your own, what did you do, Mr. Kapoor?
I had a consulting company which was called Channel Capital. So it was basically doing management consulting.
How were you associated with D1?
During the course of working on my own and Channel Capital, I met D5, and we started discussing different projects, and he had a lot of ideas, which we wanted to convert into tangible businesses. So we used to create pitches and go and meet potential investors to see if they would be interested in joining hands with us to set up those ventures. So D5 was actually consulting for an organization in Oman, which was a company called Star Modern Industries, which he started. And there was an interest on behalf of that owner in Oman to sell that company and close that business. So we decided that it would be a good idea to go and pitch this opportunity to some investors. So we made the pitch to the defendants 6 to 8. And we had an agreement from them that they would be coming in as the potential promoters and buyers of that opportunity. So that is how Velocity Industries was formed in India, which was basically to take over the business and assets of Star Modern Industries on Oman. And bring that business from Oman to Dubai.
You connected with D2.
Velocity Ventures.
And velocity.
This was an entity which me and D5 created to act as our entity to represent our mutual interest in any of the projects going forward. So Velocity Ventures was created as a company to act as our shareholding company in the different entities.
What was your relationship with D3?
As I mentioned, that there was interest from defendant 6 to 8 to participate in the investment into D1. So they decided to mutually form a company called Umaku Finvest, to represent their mutual interest. And Velocity Ventures, which is D2 and D3, combined their shareholding to take over or set up Velocity Industries.
Kapoor, can I request you to take the H bundle, access the H?
Yes, I'll just open it on my other screen. Yes, please.
Yeah. What page do you want?
H1 itself.
H1. Yeah.
Yes.
Could you identify what this document is?
This is the Memorandum and Articles Association of Umaku Trade Invest Limited, which is D3.
You can go to H16.
H16.
Yeah, I'm just reaching there. Yes, please.
Are you able to identify the signatures on this page?
Yes, I can identify the signatures of Mr. Parag Gupta, Rajinder Makijani, Mrs. Makijani, Mr. Abhinav Bansal, and Sanjay Bansal.
Thank you, Mr. Kapoor. May I request you to now come to H17?
Yes, Mr. Vajani, please go ahead.
Is this the sanction letter dated 20th February 2014?
That is correct.
Is the total sanction herein for 3.10 million US dollars?
That is correct.
If may I now request you to go to page H28.
Yes, I'm there.
Could you identify who has signed for D1?
Yeah. Two signatures. One is my signature, the other is the Mr. Ravi, which is D5.
Overleaf on the next page, page 29. Would you identify that the signature is yours along with D5 and D4 and these
I can see only three signatures here, so it's
right.
D7, D5, and D4, yes.
And yourself.
Yeah, and I'm talking about myself included. There are only three signatures.
That's right. That's right. Absolutely.
That's right.
Okay, now go to the next document, which is H31.
Yes, please.
Could you identify this document?
This is the facilities agreement for the facility of 3.5 million.
Dated 18th of March 2014.
That is correct.
May I request you to see page H33?
Yes.
Is it correct to suggest that there are initials made by you on two places on this page?
That is correct.
Could you identify the other three initials?
I think I can. I mean, one is Ravi, one is Parag Gupta. Myself, of course, is there. But it will be difficult to identify initials. I mean, if I look at who finally signed the documents, I probably might be able to correlate, but I cannot identify initials.
Is it correct to suggest that you have initialed every page of this facility agreement?
If we check every page, yes.
Mr. Kapoor, just for my bit, if you take page 834, for example, is yours the signature to the far left at the bottom?
That is correct.
Thank you.
Yes, I've reached the last page, which is page 40 of 44. Till that time, yes, all initials are there. H70.
870, right?
Yes, please.
And correct that you have signed for D1 as a director on 870.
Yes.
You identify who else has signed with you as a director?
Yeah, it's D5. So Ravi Kuchimanchi.
Next page, 871.
Yes,
It bears the signatures of 4 persons.
that is right.
Could you identify the 4 signatures from top to bottom?
They are identified with the names under the signature. So Rajinder Makhijani, then there is no signature for Devika Makhijani, but then there are signatures for Parag Gupta, myself, and D5.
Do you identify these to be their signatures?
Yeah, to the best of my knowledge. I mean, I can't remember every signature, but yes, it's there because this was verified by the lawyers who created the document. We had to sign in front of them.
Thank you, Mr. Kapoor. And that if you go 3 pages down, which is the schedule to this agreement, it also bears your initials.
That is correct.
May I then take you to the next document that was signed, which is H75.
Yes.
Could you please identify this document?
Yeah, that's the account pledge agreement.
And at H77,
Yes.
it bears 2 initials from your end.
Yeah.
And the initials of D5.
That is correct.
And going up to page H88, it would bear your initials along with D5.
Page 84, you said, right?
88.
Yes, that is correct.
And at H89, it bears the full signature of yourself and D5.
That is correct.
And go now H91.
Sorry, H what?
91, your lordships.
Thank you.
Yeah, it's the master assignment agreement.
Yes. Dated 18th of March 2014.
That is correct.
Where the cover page is initiated by you and D5.
That is correct.
And right up to page H129, except the blank pages, which are the back side. It bears your initials.
Not quite right, but it probably doesn't matter. H93, for example, doesn't. But it matters.
Yes, 93 is the index. 7 except the index and the blank pages. Going up to 130, which is also a blank page. 7 except the index page and the blank pages. It bears your initials as well as D5's initials. Are you facing any issue, Mr. Kapoor?
Yeah, the document just takes a little bit longer to scroll. For what reason? And then page number 121 is not blank, but there's no signatures. It is just a schedule which says invoices. So that's not signed. Yep, I'm on page H131.
That's right. And does that bear your signature as the assignor? Mr. Ravi Kuchimani's signature below you as an assignor?
Correct.
May I then request you to go to H133? To identify this document to be the security agency agreement dated 21st January 2015.
Just a minute, Mr. Vajani, the document is still opening up. Security agency agreement, yes, I'm there.
Yes. You identify this to be the security agency agreement dated 21st January 2015.
That is correct.
May I please take you to H141?
I'm there.
You identify that these have been signed by D5 and D7 on behalf of D1.
That is correct.
May I take you to H147?
One 147, yes.
To identify this document.
Says here pledge agreement.
You identify it to be the pledge agreement?
Yeah.
May I take you straight to H171?
Yes.
Does it bear the signatures of D5 and D7 on behalf of D1?
That is correct.
And I request you to come to H183.
Yes,
Would you identify this document to be the assignment of warehouse lease?
that is correct.
And if you go to H185, at the bottom it bears the signature of D5 for D1,
That is correct.
and overleaf on the next page H186
D7.
D7 for D1.
Correct.
Now may I take you to the document which is H197.
Yes, please.
Could you identify this document for me, please?
So, request for credit facilities dated 21st March 2016 from Union Bank addressed to Velocity Industries.
Is this the revised, renewed sanction letter dated 21st of March 2016?
That is correct.
Therefore, would it be correct to suggest that all the utilization requests that were made by you from 18th March 2014 to 21st March 2016 were honored by the bank?
That is correct.
Does this sanction suggest any enhancement in the limits?
Yes. 3.46 to 5.23.
As reflected on H197, am I right?
That is right.
Correct that you have initialed each of these pages right up to
Right up to?
H200.
Yes, that is correct.
And does the signature which appears on H201 to be yours,
That is correct.
along with D5,
That is right.
H202 could you identify the signatures of all the personal guarantors,
Yes.
beginning with yourself as number 1,
D6, D8, D7, D5.
you confirm that this appears to be the signatures of these defendants?
Yes.
At the bottom, for corporate guarantee given by Velocity Venture Limited, which is D2, you have signed along with D5.
What page are you on?
H202, your lordships. Harry
203.
202, Harry 202.
Okay.
At the bottom, your lordships, there is corporate guarantee, and there are 2 signatures for D2. Is that correct, Mr. Kapoor?
That is correct.
H203.
Has signatures of D7.
Or D3.
For D3, correct.
We come to H204.
$204.
That's right, Your Lordship. Having 2.
Yeah.
You are getting document guarantee for D3 by D2.
That is correct.
Would you identify the pictures on pages H205 to H210 to be the initials of yourself and D5?
That is right.
And at H211, he bears the initials for Mr. D5 and yourself for D2.
That is correct.
We now go to H220.
220.
Yes, H220.
H220, yes.
Is that a document to be identified as the personal guarantee given by yourself?
That is correct.
And it bears the initials from your end, beginning H220 up to H227.
Yes.
And it bears your full signature at H228.
That is correct.
May I now request you to scroll down to H240.
$240, yeah.
At H241, is this document to be identified as the amended agreement relating to the facility agreement dated 18th March 2014, and this agreement itself is dated 15th April 2016.
Yeah, 19th April, correct.
May I request you to go down to H241?
Yes.
We identify the initials, the line that they are appearing from left, the first initial to be of D5.
Yes.
I didn't catch that. Your microphone, when you turn it over from the microphone, I find it difficult to
So
catch
what's
it.
happening is there is a throwback and echo which is coming from Mr. Kapoor's computer.
All right. Okay.
My apologies for this. I realized that twice. I thought somebody was calling out, so I looked to the other side.
Right. Okay.
No, my microphone is right in front of me, so there's no problem with that.
Okay. That's fine.
Mr.
So,
Kapoor,
carry on.
can we identify the initials to be the first initial being of D5?
Second one is D4.
Yourself. Third one is of
D7.
D6
And then
fourth
D8.
one of D8. And this document bears these initials going up to H285.
Page H245 only has 3 initials.
Identify them?
I'm sorry, H245.
Yes, would you please identify them?
It doesn't have the signature of initials of D5.
Okay. Likewise on H247.
That is correct.
Right up to H285, we have all the 4 initials.
Yeah, I've met H286.
And this has been fully signed by D5, yourself, D6 and D8
That is correct.
at H286.
That's
Likewise, the personal guarantors on H287 signed by D6, D8, D7, yourself, and D5.
That's correct.
Page later, H288. For the corporate guarantee of DG.
That's correct.
It's signatures of D7, then D6, and then D8.
That is right.
And for the corporate guarantee to be given by D2, it's the signatures of D5 and yourself.
That's correct.
And then you have the remaining pages which would bear the initials of the parties going up to H293.
Yep, that's correct.
And H294.
Yeah,
There is a complete signature for D1 by D5, yourself, D6, and D8.
that is correct.
And on the next page, which is H295, there are signatures as personal guarantors by D6, D8, D7, yourself, and D5.
That is correct.
At H296, for the corporate guarantee of D3, it is the signatures of D7, D6, and D8. And for the corporate guarantee of D2, it is D5 signature and yourself.
That is correct.
Thank you. We can now go straight. Three to eight.
And there.
Is this the
This is the
sanction letter?
yes, the enhanced credit facility from 5.23 to 10.44.
This is dated 12th of June 2017,
That is correct.
which would also mean that the utilization requests that were issued by you after sanction on 21st March 2016 and the agreements and guarantees given on 19th April 2016 were honored up to 12th of June 2017.
That is correct.
If we go to the bottom of that page, which is H3 to 8, it bears the initials of D5, yourself, and D6.
That's correct.
And if we have those initials going up H330,
That's right.
and at H331 for D1, it has been signed by D5, yourself, and D7.
That is correct.
Next page, H332. It bears the signature of the personal guarantors.
Yeah.
First one being yourself, second one being D6 has not signed and D8 has not signed.
Yeah.
Then we have B7 signature. Then we have B5 signature.
Correct.
At H33, it bears signatures of self or D.
I didn't catch that.
At H33,
Yes.
it bears the signatures of I and yourself for D2.
That's correct.
And number 2, it bears the signature of D7 or D3.
That's correct.
Next document would be H334.
334.
Yeah, I'm at H334.
Is that the master facility agreement dated 25th of November 2017
That's correct.
in accordance with the 12th of June 2017 sanction
Correct.
for 10.44 million USD.
That's right.
This document, beginning from H335, going up to H397, bears your initials along with D5.
Yep, I'm just checking this page by page now.
Yeah.
Mr. Vajani, I'm not sure how many more documents we need to go through, but is there any real dispute that this defendant signed or initialed these documents?
This defendant has come back and said that I have been discharged of everything. He has not admitted any of these documents or signing of those, and then has said that I have been discharged. It is for the claimant to prove its claim.
Okay.
I apologize. In fact, I find it very tedious. Had there been an admission of signature, would have just gone straight down.
It's not that it's tedious, but it's just that if it wasn't necessary, then so be it. But
I apologize for your lordship.
Carry on anyway.
H397.
There's some noise in the background. Someone seems to have fallen asleep. Anyway, the noise has stopped, but so is the case. What's happening? Mr. Vajani, have you got any questions?
No, Mr. Kapoor verified pages right up to age 396.
I am doing that. I'm scrolling down. Yeah, I'm at 397.
Thank you, Mr. Kapoor. And at 398, it bears the signatures for the borrower, that is B1, containing the signatures of B5 and yourself.
That is correct.
And the next page, Schedule 1, contains again the full signatures of B5 and yourself.
That's correct.
And then in this agreement, including all the schedules, go up to H403, which bears the initials of B5 and yourself.
That's correct.
At H404 and H405 bears the signatures of B5 and yourself.
That's right.
And at H406 onwards, up to H409, sorry, at up to H407, it bears the initials of B5 and yourself. H408, it bears the signature of B5 and yourself.
That is correct.
H409 bears the initials of B5 and yourself. And at H410, you have again signed with B5 or B1 as the borrower.
That is correct.
May I then request you to come to H435? Is that document the personal guarantee?
Personality, this one. 435, right?
H435.
Yeah. It's my personal guarantee.
Your personal. And does it bear the initials at the bottom?
That is correct.
Does it have a notice on the top?
Notice on the top. I'm sorry, I didn't understand that. Which page are you on?
H435.
Yes.
Can I read this notice?
Personal guarantee. Notice to the guarantor, right?
To the guarantor. Once you sign this document, you will be legally bound by its terms. You are liable to the bank instead of or as well as Messrs. Velocity Industries LLC, a limited liability company established under the laws of UAE, having trading license number so and so, and its registered office at so and so, the borrower, to which your liabilities under this document relate. You should get independent legal advice before signing this document. By signing this document, you agree to be bound by its conditions. Do you read that?
Yeah, I read it. Yep.
Then this personal guarantees bears your initials on pages 8435 going up to H450.
So we are on H448. H451.
Sorry, my apologies. 451 has your signature at the top. Thank you, Mr. Shane. Sorry, I didn't realize I was muted.
That is correct.
Thank you, Mr. Hope.
Mr. Vajani, we have reached six o'clock.
I was just going to come to that I finished this section of the documents, and may I continue tomorrow morning?
Yes. We might as well meet at 9 o'clock tomorrow, 12 o'clock Dubai time tomorrow. Unless anyone has any other suggestion, I don't think we're going to gain much by starting half an hour earlier or an hour earlier. So we'll resume at 12 o'clock Dubai time tomorrow. I'm not sure what time that is in India. Mr. Shaheen, you want to say something?
One humble request, Your Lordship. Tomorrow being Friday, can I have a short break 1 to 1:30 for prayer?
1 to 1:30 Dubai time.
Yes, if it can be combined within the lunch break, it will be good. 1 to 1:30, half an hour.
Yeah, yes. We'll just take a half-hour break at that time. If you remind me, will you, please? Yes.
I
Hello?
I have one more document to complete, but I'll do that tomorrow morning. I won't detain the court at this hour.
We'll do that tomorrow morning. Right, we'll still resume at 12 Dubai time tomorrow. Thank you very much.
Thank you, Your Lordship.
Thank you.
Can you all try and have some discussions about future progress before, because at the end of tomorrow we must resolve what we're going to do. Okay. Right, thank you.